that out of 3 matters, 1 matter the appellant has already died. I waited. And other 2 matter I kept it on 12th. Let us see by 12th he may get the
Correct.
summary.
I-
Why to summon?
I'll inform.
Why to summon him? Just
Pardon, my lord. Item 169, my lord. Last week I have also mentioned the appellant has died, my lord. 200 rupees trap. The complainant had not supported the prosecution case, my lord.
if time permits, I'll do it.
Yes.
And if time permits, definitely.
Short note also I have prepared, my lord. Short note, my lord.
Let us finish the mentioning. Because mentioning it. He started already. Yes.
Item 56, my lord.
Yes.
There is no entry order, my lord. Arjun, any order, my lord.
Let us wait. Let us see. Let us follow a system.
My lord.
Out of turn, some matter is listed. Listing is so difficult. Once it is listed, don't ask for adjournment. I'll see if it
No, some instruction needed, my lord. That's it.
ये करके रखो. When
State
it
is the party. State is the party.
if it is not required, I'll definitely do it. Tick मार के रखो. Because what is happening, I'll tell you. Few matters are listed.
My lord,
It's
is
very
all right.
difficult to get listed. And you ask for adjournment, then I'm.
No, some unavoidable circumstances
after
is
lunch,
required.
there is no work.
No, some unavoidable circumstances is required.
Okay. I'll just check it out. I'll recommend it. Don't worry.
Pardon to mention that
Please, chapter.
Mr. Simadas is appearing in item 95. He has met an accident and the doctor has advised for a period of 3 weeks. Today morning he has also telephoned me. He is, I told him,
Wherever Mr. Das is appearing, I'll recommend it.
I pray only interim order to continue. As per,
I'm not saying anything. If it is there, I will not touch that file.
well, I have gone to his house. Actually, it is bandage.
I know he is not well. So
Doctor
wherever
has,
he is appearing, it is automatically urgent. I will
Doc-
not take up the matter.
doctor has advised for period of 3 weeks.
He is not well. Yes.
But I pray only interim order to continue. Okay, sir. Interim order to continue.
Yes,
Say
yes.
good. Now, authorized officer
Was
proceed.
the interim order till today?
Yes, my lord.
Or then it has to continue.
Item 95.
95.
Interim order to continue.
Mr. Suman Das is not in this post. Hence, urgent is sought. Yes.
Item 85. Notice was sent to the accused lord. Has not been traced out. So
We'll see. If it necessary, some direction has to pass to locate. I'll direct the prosecution to get it. Yes. Any mentioning?
Pardon, Your Lordship. Bail number 2176 of 24 was specifically adjourned on 18/6, but not yet.
Don't mention bail matter. Let us follow a system. No jumping. It will be listed. It will be listed. Don't worry. It will be listed.
Specifically adjourned on 18/6.
I'm assuring you it will be listed. Give it, but no priority to anyone. It will go in a system. See, once you give priority, then the only mentioning nothing, we will achieve nothing. Better have patience. All the matter we will try to get it listed. Slowly, every matter will be attended. Don't create a chaos out of it. Okay. Yes.
This case for early hearing of the
Sorry.
early hearing of the case.
Which one?
CRLMC 5104.
That also the same thing which I told. I will follow a system so that no grievance is left. We'll take care of it. Take it. Just see when it is being listed. No priority is given to anyone. That's the best way of doing it. Yes. Any mentioning anywhere?
My lords, I'm on
Yes,
this.
yes.
My lords,
Yes.
may I make a mention of a CRLMC?
You have you heard what?
I did, my lords. That's a.
It's good for you also.
I'm obliged.
Sweet. Yes. Item 1. I am not inclined to interfere with the matter, so we will be discussed. Item 2. The revision is allowed. Item 3. The revision is allowed.
Item 4.
I have granted the benefit of probation of office by maintaining the conviction.
5.
I have increased the fine and period already under.
Item 6.
I will increase I have increased the fine amount and granted the benefit of probation of offence act and directed the state to pay 7,000 rupees as honorarium to the learned amication in the assistant court.
Item 7.
I have granted the benefit of probation of offence act while maintaining conviction.
Item 8.
The period already undergone and the fine has been increased to 7,000 rupees.
Item 9.
The period already undergone and the fine is increased to 10,000.
Item 10.
The period already undergone, fine increased to 5,000.
Item 11.
Benefit of probation of offenders act is granted by is granted. No, you have given something else. No, two matters.
26.
The same thing. One probation of offenders act is given. Yes. That is
Item 12.
Trinath Maji. The same probation of offenders act.
Item 13.
Period already undergone. However, the fine is increased to 3,000.
Item 14.
Custody, the period already undergone, the fine is increased to 10,000 rupees. And wherever the fines are imposed, 357 is applied and compensation is given.
Item 15.
Period already undergone and the fine is increased to 10,000 rupees and to be disbursed to the victim under 357 CRPC.
Item 16.
Sentence already undergone with 10,000 fine to be paid to the victim under 357.
Item 17.
Provision of offenders act benefit is granted and the fine is increased to 20,000 rupees and default fine for about 2 months, and to be the amount to be deposited shall be disbursed to the victim under 357 CRPC as compensation.
Committee.
Provision of offender sex benefit is granted, maintaining the maintaining the conviction. Provision of offenders benefit granted, maintaining conviction.
Item 20.
The JCL is let up for the period he is already undergone.
Item 21.
Maintaining conviction, benefit of probation granted.
22.
Period already undergone.
23.
Allowed. And conviction is satisfied.
24.
Conviction is satisfied, the petition is acquitted.
25.
Period already undergone, conviction maintained. The petition is executed, revision allowed.
27.
The revision petition is
28.
with a provision of offenders act granted while maintaining conviction. The criminal revision petition is dismissed.
30.
Sentence already undergone. Fine is increased to 20,000 rupees to be paid to the victim as a compensation under section 357 CRPC.
31.
Maintaining conviction, provision of offenders act benefit is granted.
32.
While maintaining the conviction, the provision of offenders act benefit is granted.
33.
The appeal filed by the government is dismissed.
34 to 51 except item 48.
That is one matter. And all these matters are covered by the judgment of this court, and judgment already passed in earlier matter in Sadanand Mishra versus State of Orissa. Therefore, all these appeals are dismissed. 40.
48.
This is allowed. Revision petition is allowed. Revision petition is allowed.
53.
The revision petition is disposed of with certain liberty granted to the petition.
54.
The revision petition is allowed.
55.
The revision petition is allowed.
Today also Tuesday. Your Lordship, plus 50.
If your lordship permits, my lords, may I have a submission, my lord?
Yes.
All my friends join with me, my lords, in putting on record again our appreciation, deep appreciation, genuine
Thank you very much.
appreciation.
It's all
of
possible
all
because
the
of the-
all the hard work your lordship put in that in disposing so many matters, my lord. In fact, after your arrival, things gather momentum, my lords. All
Because
those
these
matters are
were
2011 and
pending
12.
for
Yes.
years and
11 and 12, correct? my
And
lords?
the,
Yes.
the effective assistance granted by you people was
Your Lordship will ever have.
commendable. Commendable. Thank you very much. Let us do in the next trip. Let us do a little more than
More
what
than-
we did today.
Century Lordship.
Thank you very much. Thank you. Yes. Yes.
Item 56.
May I please to mention?
One.
May I please to mention, my lord?
Mentioning is over. Anyway, you mentioned, no problem.
CRLMC number 4870
Hmm.
2023 lordship. This matter to be, this was the specific adjournment lordship. This matter,
Everything will come. I have already commented about it.
yes, lordship.
Wait for some time. Everything will come. Don't worry.
Lordship.
Tomorrow only the matters pertaining to all bail matters pertaining to 2022. All the matters will be listed tomorrow.
Oh, bless.
So need not mention. Oh, yes. What is this matter?
56.
So urgent. Urgent, and whoever is asking for adjournment, give it in the September.
Yes, madam.
Give it September. Don't.
Continuously 5-10 session.
Otherwise, very difficult. Yes.
57.
Lordship, may I take off this matter on some other terms.
Yes, sir.
This is that cryptocurrency matters, my lord. So your lordship wanted me last occasion, how much time you need? Because in the meantime, talked with some officers, my lord, that they are depending on some IT professional from Bombay, my lords. They are, because it's a fast case.
Keep it in the last week of August. Last week of August. On request, huh? Yes.
58.
Charge sheet has not yet been filed.
No, instructions going on. The lordship wanted that particular instruction.
Yes.
I contacted him because that we are depending on that technocrats from Bombay, my lords, because the local people in that cyber capable that cyber section, my lord, they don't aware all this cryptocurrency matters. They depend on this.
Okay. Yes.
May I please, lordship?
Yes.
My lord, out of 4 accused persons, 3 accused persons has been granted bail by the Honorable Court. I am supplying the copy of the, it's a case.
Sorry, item number 58.
Memo file for withdrawal of
Memo,
case.
I-
Partha sir can I one Mr. Partha sir.
Memo filed for withdrawal.
Somebody manner the,
Your matter is
but I
59.
noting is that a memo for withdrawal of the.
Sorry,
File by
59.
the petitioner is flag B.
Your matter is 59.
Withdraw.
59.
My lord, that is my matter, my lord. My lord, I have, in the meantime, my lord, out of 4 accused persons, he has been granted bail, my lord. It's a case, my lord, where 20 grams.
Who are
of-
you? You are Sadashiv Naik.
Yes, my lord.
What
Where
are the offenses?
My lord, 21B of NDPS Act, my lord.
How, what is the recovery?
My lord, 20 grams of brown sugar was seized from 4 accused persons. Out of them, those, my lord, 3 has been granted bail by this.
No, no. What is your role? Let us see.
My lord,
Sadashiv.
Sadashiv, my lord. All are present while, my lord, 20 grams of brown sugar.
Illegal selling brown sugar in the house of one Sadashiv.
Yes, my lord.
It was in your house.
Yes, my lord.
If you are in the,
My
That
lord,
is not,
My lord, there is
he is involved in the similar nature cases, for that reason his fair for will is
then 37
that
bars,
is
you can't help it.
my lord, it is below commercial quantity. 37 is not.
Need-
No, you are involved in other cases
Other-
also.
My lord, so, my lord, therefore, my lord, since my lord 2000, my lord, in the month
You
of
are in custody since
my lord 18/10/2023, 23 years young boy. My
23 years. If you are saying 5-6 decades,
lord. My lord, 23 years young boy, my lord.
that young boy should be prevented from.
No.
See, ganja and all one can understand. Brown sugar, all these things are it is less than commercial quantity.
Yes, my
Nature company, but he is involved in similar nature cases, for that
Then
reason also
that
he is
condition
earlier.
I'll put it, and you will never come out.
For that reason
that
also
condition
earlier
is must.
acquitted. While allowing prayer for bail other accused persons, for that reason he also be rejected.
You do one
No, no,
thing.
that was not-
You try and get bail in other matters. Here I'll give you.
In that case, he is on bail.
Then, but that condition will be there.
Yes, my lord, he is on bail. That
What do you
makes-
say? Less than commercial quantity. And 2 accused have already been granted.
Three accused, my lord.
3 accused. No. 3 accused have already been. No, 3. You have given 2 only.
My lord, that is in one case, my lord, 2 accused.
3 accused have already been granted bail. Below commercial quantity.
Well,
But subject to condition that he.
he will not commit similar type of offense.
No, and
He will appear
verification.
before the-
Verification and all these things.
My lord, he has only one criminal antecedent. That is of similar nature. That is also, my lord, below commercial.
No, last time the court has directed you to give the instruction,
Instruction,
bring
that is-
instruction antecedent.
Antecedent matter, another case matter similar nature.
Show me.
Lalbagh case number.
मुझे जाननी
My lord.
That was the
My lord,
order
on the
last.
case number 380 by dated 9/8/2022 under section 21B 29 NDPS Act.
What is the recovery there?
That is-
That was also 21B, below commercial quantity.
21B. 29 NDPS Act.
Right down.
Except this case, there are 2 cases. One is similar nature, another is.
Allegation against the FIR that informant got information about selling the brown sugar in the house of the petitioner.
Yeah.
So that makes the petitioner. Petitioner. Thereafter the informant. This court, while allowing the VLAPL number 13962 of 2023, grant on 5/4/2024, admitted 2 of the co-accused persons on bail. Subsequently, while allowing VLAPL number 3580 of 2024 on 26/4/2024, another co-accused has also been granted bail, ungranted bail. The petitioner is seeking parity with the co-accused persons and submits that the recovery of brown sugar is below the commercial quantity, below the commercial quantity. Although the role of the petitioner is different from the co-accused persons, but the fact remains that the petitioner remains in custody since
18/10/2023.
18/10/2023. And charge sheet has been filed.
Yes, madam.
23, and the co-accused persons were given granted bail and with the petitioner on bail subject to condition. The condition is issue the condition gender representatives are cooperated with the report the IIT for the police station being physically present on 60 tapi 432 and subject to further condition that is not involved in any other similar offenses.
Some condition below.
What is the offense?
302, ma'am.
302.
Yes.
CD call.
Yes.
Okay. September.
CD is there, my lord, available.
CD is there.
Yes, my lord. Postmortem report and my lord, the eyewitness evidences are there. And this case is fit for
September.
trial, my lord.
September.
My lord.
Yes.
May I please, Lordship? Lordship, I have entered my appearance on behalf of opposite party.
What is this matter?
Actually, yesterday night the brief was transferred to me, my lord. Just I need some time to file the show cause, ma'am.
What is this matter? Let us understand.
Cancellation of bail, my lord.
Nobody is there.
Here the petitioner is the victim, my lord. I don't know, madam. Appearing for the opposite party number 2.
That's right. Nobody is there. Take advantage of that.
My lord.
Wait. I'm passing it over. If he will not come, then he's not interested that your bail should be cancelled. Wait. Wait. Pass it over. 62. Yes. Bail. Hmm? Challenge bail. What is challenge? What is this matter about?
62 might not be a private property. Government is not a party.
Pass it over. We'll see. Yes. 63. Withdraw. Withdraw.
Yeah, please, Lordship. Matter 2 is time to remove all the defects.
What are the defects? What are the defects? See, you have come against an order rejecting your application for discharge.
My lord.
And there is an urgency involved in this matter. Otherwise, charge will be framed, your matter will be infracted. Why are you wasting?
That is in 2022.
So nothing survives. Charge might have been framed by now.
Madam, he has only prior that he may be discharged under section 307 offense is there.
No, all the contention will remain open.
And one have time to remove all the defects then.
Like lordship, my lords, in this matter, my lord, by this time also charge has not yet been framed, my lords.
So raise all these points at the frame of.
Lordship may call it up any day this week, if Friday by
No,
Friday also. my lord.
see, there are a lot of matters and everything is getting, clogged because of the adjournment system.
The first time the matter has come up, I humbly pray, my
First
lords.
time, the matter is to be heard in the
My
first
lord,
time also.
my lords, I admit that, my lords, but I pray, my lords, can
But you
can
have a
lordship?
different practice.
No, my
First
lords,
time you don't argue.
no, that is not the case, my lords. So, lordship, I undertake to argue the matter on the next date, my lords. Lordship may post it to Friday, I'll remove the
No,
defense.
according to, see, we have to follow a system. It is getting very difficult. I'll pass it over, come and argue.
My lords.
I'll pass it over.
3, 8 and 14, there are
Change
3
of
defects.
nomenclature. What you, it should be revision what? It should be revision.
Lords.
It should be a revision.
No, my lords,
Against discharge, na?
my lords.
You should file a revision. That is
Usually
why they say.
482 is usually maintainable, my lords, with my
That's
lords.
the objection, what to do.
Staff reporting.
The registry has pointed out certain objections which has not yet been cured. The petitioner is given liberty to cure the defects within during the course of the day. If the defect is not cured by during the course of the day, without reference to the court, the petition stands dismissed. In the event the defect is cured lease the matter next month.
Can it be
Yes.
by one working day, my lords, because files will be before
Today,
lordships.
full day working today.
My lords, files will be in my lordship's docket and
By
for that.
tomorrow.
My lords, that.
Tomorrow could be.
My lord. Much obliged.
Otherwise, you won't do. I know that.
Much obliged, my
Ah.
lords.
Yes.
My lord, may I please? I am a Bhavani Patna Versal Court, my lord.
Yes.
I am filing application of quashing of FIR.
Yes. Charge sheet has been filed.
Yeah, charge sheet has been filed, my lord. I have annexed it. Yeah, yeah. My lord, it is some other offense and the main is the atrocity act. It is only atrocity act, my lord. He is a
Yes.
reporter and in the FIR there is no such allegation which is aspiring to his caste. No allegation which is aspiring to his caste, my lord.
Now,
As well as-
charge sheet has already been filed.
Yeah, my
In the
lord.
FIR, there may not be any allegation, but after investigation, something might have come. Let us
My
see
lord,
the charge sheet.
My lord, may I, pardon me, my lord. Charge sheet has been filed, my lord. Charge
Show
sheet,
me
my,
the Sir,
I
show
have-
me the charge sheet. In the charge sheet, something might have come against you.
City has not. My lord, can you say what is his prayer, my, what is his prayer?
What is your prayer, madam, sir?
to send notice to the party, my lord.
No, 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 no.
What is his prayer, my lord? Prayer portion, my lord, can you say?
In the council for the respective party, FIR number so and so, bearing number so and so, so and so, so and so, pending is so and so, so and so. What is this? What's the admit the question? What is this? He
Yes,
is
my
not
lord,
asking
what
for
is his
question.
prayer, my?
Why have you seen your prayer?
Yeah, my lord. I have called for the
What is
record,
asking?
admit the CMC and issue notice to the party. After hearing the council as a party, FIR number may be quashed. My lord.
Quas, where have you written quas? You are reading somewhere
After
else.
hearing the company party, FIR may be pending in the party.
Right.
I have called for you.
In this petition, petitioner is when the charge sheet was filed?
Charge sheet was filed on 23, my lord.
Date.
Date is here, not clearly mentioned here, but I have been here.
You withdraw this petition and file a fresh one, challenging the charge sheet. This petition is, not properly drafted also. It's better that you should do. Land Council for the petitioner seeks to withdraw this petition to file a fresh one in view of the fact that in the meantime, a charge sheet has already been filed. Therefore, the petition stands holds up with the liberty as well. Yes. Next. 66. What? Passing.
Passing up.
Yes. Nobody is there. What is the stage? Charge sheet filed.
Yes, charge sheet filed.
Charge has been framed. See, when the charge sheet was filed, this petition is pending in 2023 November. If the charge sheet has already been filed, cognizance might have been taken. What is the situation? Do you have any idea?
No, my lord.
So I am passing it over. Let the petitioner come. Huh? We'll
My
see.
lord.
Pass over. Yes.
67.
Yes. What is this matter? Cognizance of.
My lord.
Yes. Pass it over. Let us see. Huh? Yes.
My lord.
60. No, these defects are serious defects or ignorable. Forget. Yes. Most small defect, ignore.
Madam.
68.
68 can be taken up 2 weeks after because there is a talk of settlement is going on between the parties.
What are the offenses?
And 498 and other alleged offenses.
I'll send it to mediation.
No, there is a chance of mutual divorce.
That you can sort it out there.
Already talk is going on between the parties to settle the matter and file a mutual divorce before the.
So
family
when do you want?
2 weeks after, my lord.
Huh?
2 weeks after.
Then counsel for the petitioner submits that this is a matter arising out of a matrimonial discord. The parties are likely to settle the dispute. Therefore, the petitioner seeks 1 week adjournment. Leave the matter next Monday, whatever, 12th or 13th. 13th. Yes.
69.
Yes.
59 copy notes of madam.
Huh?
Copy notes of.
What is this matter? This is for (15 to 2023). This is a private case.
My lord.
Cognizance is taken. Pass it. Yes.
70.
My lord, two CRLMC, there your lordship. First one 618 is for quashing of the criminal proceeding on the ground of compromise. The victim had married to the petitioner.
No, second one is 6166.
My lord, second one is
First one is 4959.
49.
Yes.
My lord,
Yes.
first one your lordship kindly.
What is the second one?
Second one is your lordship 311 petition was rejected of the victim against the site order your lordship.
What are the offenses?
My lord, 376 2 and 6 of the.
Press address has not been provided.
Press address.
Yes.
Notice was issued. Let's see. Acha, interim order passed earlier and very nice. The requisites have none appears for the petitioner. Requisites have not been filed. There was an interim order passed by this court on 18/3/2024. In the event the requisite is not filed by tomorrow, the interim order passed by this court on 18/3/2024 shall stand vacated. Stand vacated. This the matter in second week, third week. Okay.
72.
But in this case, the NBW was passed on the
Yes.
8/5/2018 for the non-appearance of the petitioner.
NBW.
Madam, that was challenged. Earlier on the order, this honorable court has directed me to file an affidavit stating that any other case, two anticipatory bail was filed and that has been withdrawn on the same date.
No, your lordships.
Two anticipatory bail, that is ABLPL number 7224 of 2018, which has been withdrawn on 23/7.
Yes, Mr. Naik, do you have
Your
any
lordship,
objection?
yes, your lordship. Your lordship may kindly come to paragraph 5 of the petition.
5. Okay.
In paragraph 5 of the petition, he is stating that the petitioner came to know about the order of NBW in the month of November 2023. And from the co-accused of the case, thereafter he searched his advocate but could not found, and he engaged another advocate and applied for the certified copy.
What is your objection?
My objection is that he's lying, your lordships. He had filed an anticipatory bail on same cause of action.
If NBW is issued, why have you not executed?
No, your lordships, NBW was issued for a moment, your lordships. Your lordships, NBW
No,
was
why
issued.
you ask me, answer the question. Why have you not executed? the NBW?
Just
Who
because this,
stopped you?
just because this petition was pending, your lordships, as a matter of respect for the High Court, we have not executed. Otherwise, we would have arrested him. We know him.
No.
Now, your lordships may kindly come. Your lordship may kindly
Don't
come to
say
the
that.
date. Your
What
lordships,
kind of respect you have, you know.
your lordships, there was an
You don't
interim order on
execute the
18th.
NBW. If somebody comes to the court for cancellation, you should be happily accepting it.
No, your lordships,
And
he
impose some
went.
cost.
No, your
And
lordships,
impose some cost.
lordship may hear me for a moment. Your lordships, when the NBW was issued, after that NBW, he filed an anticipatory bail.
But he is going to appear in the court. How the system should run? He will appear. I'll record his undertaking. Your work is done.
But your lordship,
why NBW is issued? To ensure his presence. I will record his undertaking. He'll go and appear in the court, and
your lordship may reject his,
available to him.
Your lordship may reject his petition. We'll ensure his presence.
No, don't do that. Don't do that. Right now, the petitioner, the present petition is filed seeking cancellation of NBW issued by which court? NBW issued by the court of
Additional
and sessions has come
Special Judge CBI, Court 1.
Bhubaneswar
CBI Court number 1.
on 8/5/2018 for his non-appearance. The land counsel for the petitioner submits that his client would on instruction submits that his client would appear before court on or before 15th of August. 20th of August. Without fail. Without fail. In the event the NBW is the execution of NBW is shall remain shall be kept in abeyance till 20th of August 2024, subject to condition that petitioner shall appear before the court and avail remedy under law. Avail remedy under law. And this and further condition that the petitioner shall deposit 1,000 rupees before the High Court welfare High Court Bar Association welfare whatever 1,000.
If it doesn't, your lordship, if it doesn't
appear on or before 20th, and I have stayed the proceeding with that.
And if it doesn't come, if your lordship, if it doesn't come, then the NBW will be executed.
I have only kept in abeyance.
Yes.
It will revive. It will revive.
Yes, your lordships.
Before 20th, anytime you appear and move application. Yes.
Lordship, a free copy of the order may be provided.
Yes. Yes.
73. May I please, my lord? May I please, my lord?
Yes.
Notice was issued on the last occasion.
Yes.
Party number 1 and 2, my lord. Private opposite parties. And as per noting, they have appeared. Yes, as per noting, they have appeared, my lord.
Appear. Okay. Please appear. Is there anyone? What is the dispute?
My lord, it arises out of a maintenance case for which the learned lower court directed to pay the maintenance. Accordingly, the present petitioner appeared and filed an application by filing an amount to the tune of rupees 48,000 that the rest amount cannot be recovered as it is time barred under section 125(3) CRPC. Consequent upon which the learned court below rejected the matter and the petitioner preferred an revision wherein the order was confirmed. So
I am just passing it over. Somebody is appearing. Let us see.
My lord.
Wait. Yes.
My lord.
Yes.
74. Modification order, my lord. Order dated 5/2024.
What modification?
My lord, instead of district and a session judge Puri, it is wrongly typed at a second additional district judge.
Oh. In para 4, huh?
Yes, para 4 and 1.
Para 4 and 1. What you had said in the prayer? You had said that in the prayer, what to do? From the prayer only we have taken it.
Correct.
Right. Correction could be, huh? Okay, allowed.
Obliged.
75.
And we are permitted to withdraw, Your Lordship.
Withdraw. Very good. Withdraw.
The IA has been infractious.
Infractious, withdraw. Okay.
Wait 3 minutes.
Yes.
76.
My lord, I have filed a petition for substitution, that limitation petition or only one has to.
Substitution of what?
My lord, of the deceased appellant. He has been
criminal
convicted in a vigilance case.
394.
Yes, 394, my lord.
The application allowed for the re-mistake. Now it's not even numbered, sir.
Number, your lordship direct for numbering it just immediately after seeing
You
the.
find it because nowadays the e-filing system and all. You file it.
I'll
And
file.
counsel for the petitioner submits that the sole appellant in the present case has expired. Therefore, he has already moved an application under section 394 CRPC for substitution. The application is not listed today. Hence, the matter is adjourned to next week.
77.
I'll put it in the weekly list. In fact, I tell you, in the absence of your application, it is abated.
As your lordship.
You have to move an application for setting aside abatement, thereafter.
Abatement will not apply.
30 days, within 30 days. It survives for 30 days. Thereafter, it abates.
As per the provision of CPC, that abatement apply. Here abatement.
That's right, but the
only section 5 petition.
394 also says, Mr. Moon that the other day argued, 394 says that it is 30 days is given for abatement. After 30 days, it's automatically abated. Then you have
Abated, I have to file a limitation petition. Abatement petition, setting aside abatement petition may not be necessary, my lord.
Maybe limitation petition.
Limitation.
So shall I abate it?
No, my lord. Your lordship keep it here.
I will not say anything.
Your lordship
Because
may
this
not
order, the
say
proceeding
anything.
will be wrong, basically.
Let it be listed tomorrow. I have no objection. Tomorrow, day after tomorrow, my lord.
Tomorrow, we'll release it tomorrow. Don't say anything. Otherwise, the proceeding will be wrong.
Also.
Yes.
77.
Kindly pass over the matter to after lunch.
What is this matter?
Yesterday, your lordship directed me to pay the check amount in shape of DD.
Yesterday it was there.
The
Where is the check?
petitioner is coming from Hon'Ble.
Draft.
That's it.
Wait. We'll dispose it. Wait. Let him.
Let's
bring. 2 o'clock?
That's it.
Let it be 2 o'clock. He's coming. He must be there in the way. Let it be 2 o'clock. Okay.
78.
But this case was before lordship earlier, my lords.
Yes.
In this case, my lord, the revision is directed against an orders rejecting her petition filed under section 457. This pertains to release of certain materials. My lord. Lords, if lordship permits, my lord, I will again sit with her lords during lunch hour because there are 10 items. My lord.
Shall I pass it over or?
Yeah, pass it over. Item para 7 contains 10 items.
Okay, you just.
So I've got instructions, few matters, but other matters I'll just have clarification.
Sort out. Yes.
For example, she has stated about that some document.
I know you have been doing it. Whatever concession.
I'll just find out any feasibilities there.
Yes.
After lunch.
After lunch,
after during lunchtime, please come and sit with me.
I can ensure a cup of coffee.
Yes.
79.
Lord, here rejecting the petition for discharge, charge has been framed which is in challenge. Matter would have become infructuous by now because all the witnesses have been examined here except the IO who is not turning up repeatedly. Even if,
Shall I give a direction to the IO to
Lord, that's exactly, Lord, that is my prayer in this.
Yes, who is appearing?
And despite the earlier order for expedite disposal also, that is there in one criminal miscase. My Lord, that number, if your lordship, I have not got the order, CRLMC number 1788 of 2017. There, this honorable court, at the instance of some other accused, directed to expedite the trial.
Right on.
It's a vigilance.
In the present
Yes.
In the present petition, petitioner is assailing the order dated 10/2/2023 passed by the Learned Special Judge Vigilance Sundargarh in TR case number 19 of 2009, whereby his application under section 239 CRPC praying for discharge from all the charges level against him has been turned down. And counsel for the petitioner, Mr. Patra, fairly.
S.K. Das, my lord.
Sorry, S.K. Das, fairly submits.
Sushant Kumar Das.
Sorry, yes, fairly submits that in the meantime, charges have been framed and all the witnesses have already been examined except the IO. However, except the IO. He further submits that a co-accused had approached this court and this court had directed the trial court to expeditiously to dispose of the trial expeditiously. Despite the said direction, the IO is not appearing before the court for recording of his evidence. Therefore, he seeks indulgence of this court in the present petition. The submission made by the Mr. Das, learned counsel for the petitioner, being a fair submission, I accede to the same and direct the trial court to make sure that on the next date of hearing, the IO of the case
The presence of IO to
make
ensure.
sure the presence of IO of the present case and record his evidence without
As expeditious as
without
possible.
without accepting unnecessary request of either side for adjournment.
My lord.
This observation.
Obliged.
Yes, this observation the petition is disposed of. I'll just come. What is this matter is about?
Is the challenging the cognizance order as well as the entire proceeding. And one time some amount was taken by the petitioner company and it was repaid by one time payment. Then there is a fraudulent settlement for which FIR was lost. That's why she
Challenging cognizance.
Cognizance and the entire proceeding.
There was a fraudulent settlement.
So kindly taken up any other day.
What is the stage? Charge has been framed?
No.
No. I think they have not even appeared in the case. It is for appearance. I'm for the informant, your lordships.
Why at this stage this court will interfere? You tell me.
Last 2 years.
The lordships should not interfere.
Your lordship,
Lordships.
this petition, your lordship, is pending. This petition is pending since last 2 years, your lordships. First time it was listed before Honorable Justice Mr. Pujari. One Mr. Pranay Das had appeared, your lordships. From that point of time, the matter has never reached.
Is there any stay order operating?
No stay order, your lordships.
Then why the charge has not been framed so far?
Yes, your
Cognizance
lordship.
is taken way back in 2022.
If they do not appear, your lordships, since they have taken an bail and then they have not appeared. So now the trial court is unable to proceed. It is for
And after that, they were again arrested by ED, your lordships, in the same case. One ECIR was registered and they were arrested by ED. And in CBI case, your lordship, they are not appearing.
in the trial court.
No, I have no knowledge. He just I have filed.
No, this is
And
pending since 2022.
22.
Cognizance order.
Yes, ma'am.
By now, charge would have been
Any other
framed.
day he will address.
He was there, your lordships. He was just there online.
I'll pass it over. Otherwise, I'll dismiss for the court.
Any other day.
Restore application. Move restoration application.
Yes, your lordships. Lordship dismiss.
Cognizance order. Why should I interfere such a huge matter?
Any other day he will personally present.
The fact that there are
Today-
lot of facts involved,
Today he has
lot of documents are there.
sent-
Then I have to virtually conduct a trial to segregate what is right, what is wrong, and all.
Any other
Is this-
day
is
he
this
will
the jurisdiction?
he is personally present and
His personal appearance is not necessary, your lordship. He is online present.
Just see if the online is there.
Yeah, some internet issue is just
Sethi internet khola phela ken janle.
just message me.
I am passing it over. Call it
Any
2
other
o'clock.
day, my lord, he.
Should we pass it over?
I'll pass it over. Let us see.
Yes, your lordships.
These matters are unnecessary pending.
82, my lord. Compromise matter, washing over.
Compromise.
Lordship's order have a glance to order 1/5/2020. My lord's order.
1/5.
1/5/24. Yes, my lord. According to earlier order.
363,
Nine.
non-compoundable offenses, my lord. Last time
Why?
you were.
No. POXO is there?
POXCO is there.
Lordship may see that. Earlier order.
6 POXCO.
Basing on that order, my lord has passed this 1/5/2020.
Right, but 164, show me 164. Want to continue with the criminal case against the petitioner on being query put by this court to
My lord's order on 1/5/24 pursuant to 9/12/23.
Lok Adalat, huh?
Yes, my lord. Both the parties have appeared before the Lok Adalat.
Now, is he now married?
Yes.
Attained majority.
Yes. That's why your lordship has kept it pending for.
Annexure 8.
Challenge the order dated 18/7/23. Annexure 8, my lord. That is annexure 8, 3 and annexure 6, my lord.
What happened in that? Evidence is closed.
Yes, my lord. In the court of the additional district cum executive magistrate, Bhubaneswar, my lord.
Evidence is closed.
Yes,
Against that he has come.
And also challenging the criminal miscase, my lord, of the same additional DCP court. In the last occasion, my lord, your lordship was directed to bring the instruction regarding the criminal miscase 306 of 2021, my lord.
See, the interim orders are continuing. Nobody is coming. Pass it over, otherwise dismiss.
My lord, may I play one thing? Last occasion, your lordship was directed to bring the instruction regarding that share LMNC status, my lord. That has not been obtained, my lord. So one date may be allowed to me. I will bring the instruction and then your lordship, thereafter it may be quashed.
None it is for the petitioner. The order dated, which order?
Order dated 13/2/2024.
24.
13/2/2024.
Pursuant to the order dated also, no instruction has been received. Therefore, Mr. Rahul seeks 1 week time. Please the matter.
84.
Lordship, this matter may be taken up tomorrow. Lordship, I forgot to get the written notes. Lordship, I have already prepared. Lordship, tomorrow. Lordship.
Let it be there, tomorrow.
Obviously, Lordship.
85.
Pardon, my lord, in item number 83, my lord. 83, my lord.
Yes.
I received instruction from my senior, Mr. Sibo Sankar Mishra. Opposite party counter dena as per the last.
What counter? He is. What is this? Which matter is talking?
Item number 83.
83. Or the one which I have already passed the order. I have already passed the order. Nobody appeared. Yes. See, yes. 84 is over.
When an interim order is there.
Yes. 85. 85. What happened?
This is conviction under section 307, 450, 320.
Somebody, yes. Yes, next.
Let's say item 80.
Yes.
Let's say item 86 call for LCR.
What is this matter?
Let's say offense of under section 498 and 4 DP Act.
Your husband?
Let's see.
Is there any settlement?
No, there is.
No.
No.
No
No.
settlement. Call for C, huh? Call for LCR. Okay. 87.
Oh, let's see.
And the weekly list, huh? Call for C.
87.
87.
Made please, my lord. Before I resume my submissions in the case.
Who is appearing for the other side?
Yes, my lord, I am appearing for state vigilance.
Yes, yes.
Lordship had
To file the motor.
on the
How many miscellaneous matters are there? No. Thereafter, how many? Can I just okay, after lunch any case we are sitting. Okay.
Lordship will hear it at 2 o'clock.
That's what I was wondering because there are a few miscellaneous.
But 2 o'clock, your lordship have kept other items. So after finishing those, or this will be first, your lordship may.
Lordship had on the last occasion. Lordship
How much
had
time will you take by the?
probably 1 hour.
1 hour.
1 hour I hope.
How much time will you take, sir?
This my learned friend has taken more than 2 hours. I will take half of it, 1 hour maximum. Maximum.
Well,
Or it may be less than that. Because speaking to myself, there is nothing in the case. My learned friend is only lingering it. But prima facie allegations are there.
I propose that I'll take it at 3 o'clock and I'll finish up at 4 o'clock. You adjust yourself. I can't give much time in small interlocutory.
Okay.
I
will be brief. I will try to be brief and to the point.
I will give you half an hour and half an hour to him and finish it up. I can't.
Okay. I will accommodate.
Hours you can't.
I will accommodate.
Let us at 3 o'clock. 3 to 4, it is concluded.
Okay.
Lordship had fixed an appeal which Lordship had heard yesterday. Whether that appeal can be taken up today.
So what do you say? Which is preferential for you?
The appeal which Lordship had heard yesterday, it can be taken up day after tomorrow.
We'll see if that time we let it come. 3 o'clock we will.
Okay.
Because this is an interlocutory stage. We will finish it up. How many matters are there in this batch?
Only one matter.
Three matters.
Appeal matters. 3 advocates are there. 3 appellants are there. Okay. One is myself, another is Devasris Panda, and another is DP Dawda.
It's 3 o'clock. Now, because of the other assignment which has come to this, and giving much time to this cases.
CRLMC has
difficult.
I understand, Lordship. I will try to be brief and face up as early as possible to the court.
And in any case, you are giving a written note. I'll have
Yes,
to read
yes,
those.
I have already given.
3 o'clock.
88.
Lordship.
In this case, Lord,
After-
your Lordship can last occasion directed me to submit the reports pursuant to the earlier order passed by this honorable court, my lords, as per the order dated 14/7/2022. 14/7/2022.
Yes, what was the order?
That was an order, my lords, directing the state vigilance to submit a report pertaining, indicating the exact role played of shop room and all. In fact,
Hey, this is for quashing or what? What is this?
in fact, this is an application, my lords, for discharge or rejected, my lords.
Discharge.
Yes. Your Lordship, kindly for a moment see the order dated 15/7/2024.
No.
15/7/2024.
Your Lordship directed, my lords, that
Yes,
the
so-
earlier order, as per the earlier orders passed by the earlier bench, my lords.
17,
That report-
14/7/2020.
Yes.
Let us
that-
see.
So let my
that
learned
report-
senior
Examine
submit
report
the
under
That report, your Lordship directed to submit, my lords.
one directed to one file an affidavit regarding to that.
Report of Justice A.K. Mahapatra कहते
Affidavit, if the affidavit in terms of the order dated 14/7.
My lords, if Lordship,
Have you filed it?
my lords, I prepared but my learned friend says the order was for affidavit.
Yes.
Then I'll put it in
No,
affidavit.
where is the affidavit order?
Yes, Your Lordship.
No. In where is the order of affidavit?
Your Lordship, kindly 15/7/2024.
Accordingly file report in the court indicating the, where is the affidavit?
By way of last and final opportunity, one more opportunity is granted to Mr. Das Nanak, Standing Counsel for the Vigilance Department, to comply with the order dated.
No, that is wrongly I have written. Affidavit is not required to be filed. I am collecting evidence of what?
In fact,
In a quashing petition.
last bench,
If the
That's a wrongly what is used. Don't see the earlier order.
earlier, that's
Your
the-
Lordship say.
1 minute. The
Yes.
order dated 15/7/2024, which is passed by me,
Yes.
is flowing from the earlier order of 14.
Yes, correct.
You can file some report, but I'm not here to collect evidence for you for any discharge.
No, I
Give affidavit, give that, give this.
No, Your Lordship may direct or else Your Lordship.
Why should we enter into an inquiry system? You are asking for quashing of what? Quashing of is an
That
order.
order rejecting
By
a discharge
which your application for discharge has been rejected.
Yes.
Isn't it?
Yes.
Show me what are the matters. Why should I enter into give affidavit, you give that, you give this?
And
Whatever is there, I have to decide.
And
I didn't realize the earlier order was passed
Yes.
by the coordinate bench. I said that comply that order.
Yes. All right, Your
That is
Lordship.
not required. You
And-
just forget about the earlier order.
and the-
Satisfy me on the bench.
And the case was also posted to
So may-
25th for 2022 for framing of charge, my lords.
So
But
may I pray Your
We are
Lordship.
not here to collect material
Yes.
for you
Yes.
by any manner whatsoever
Yes.
to support your case. You have to satisfy the court that on the basis of the material which is available on record, whether a case is made out or not.
Yes. So may I pray Your Lordship can taken tomorrow or day after tomorrow, any date, Your Lordship.
Today is not auspicious.
Or not prepare that, Your Lordship.
I'm passing it over. Prepare and pass.
if Lordship permits, my lord,
Passing on.
prepare you.
Knowledge.
Tomorrow.
Tomorrow.
Okay, tomorrow.
Tomorrow or day after, any day.
Charge has been framed?
No. The case was posted to 25th for
No,
2022.
there is
Yes,
an order of a clear bench that he will move an application for
Acha,
time
for that reason,
for adjournment.
thing
See,
have been stalled.
he must be asking for adjournment, therefore here also adjournment.
No, I have not taken.
Get ready
Your
tomorrow.
Lordship kindly also taking pass over, Your Lordship. I have no.
No, tomorrow.
Tomorrow,
Because there are many matters.
Yes, yes, sir.
Tomorrow, get ready and come.
Yes.
Then, my lord,
And give a copy to
I'll give a copy. my lord.
Give
Yes, sir.
give a copy.
Day
Take a
after-
copy
Yes.
Let him go through, my lord. Let it day after tomorrow.
day after.
Day after. So
Day
that
Day
he
after.
can go through it.
Yes. During course of the
Day after.
deep problem.
89.
Yes, sir.
Notice was issued to OP number 2. I think it is sufficient.
Notice sufficient.
Another.
Yes, it's sufficient. Nobody entered appearance. What is this case, sir?
You say again, I come up against the discharge.
In a trap case. And my learned senior is a generation of imprinting all the, incorporating all the statements of the important witness. That's a decoy and a shadow witness recorded under 164 CRPC. At page 18, my lords, the decoy statements are here. The petitioner for Lordship, my lord, was the cashier, my lords. The executive engineer asked the decoy that you deposit 10%, that is 17,000, to the cashier. This gentleman, the petitioner for Lordship, my lord, is a cashier, my lords. So, and in a particular trap, he was successfully caught red-handed, my lords. Now, my learned friend's submission that I'm not the person who demanded, my lords. But they, in part, in view of the latest, the amended provision of PC Act, my lord, to which is introduced in 2018.
Money is recovered from him.
Yeah.
Money is recovered.
That's true. But my learned friend, that he is not a public servant. That's similar, I say, my lords, you will also turn to section 18A, capital A.
18 capital A.
Capital A. Earlier it was 18 was there. You will also turn to the page 46. I'm sorry. Sorry, 7A. Sorry. 7 capital A.
7 capital A. Yes.
And there is a judgment of Supreme Court also that somebody demanded and that apno taku dei diyantu. So both stand at par.
Which whoever accept or obtain.
They stand at par. In my at page that amendment provisions. 7A capital A.
Who is the public
servant? Yes, my lord. 7A, my lord. You'll also turn to page 40 of that pink color. The lordship right hand notes. No, in that book's notes. Page 40, my lords.
40.
40 notes.
Yes. Yes.
Section 40 and that section 7, my lord, offense relating to public servant being bribed. Any public servants. So section 7 takes care of the public servants. Let's turn to the bottom portion of the same page. 7A. Taking undue advantage to influence public servants by corrupt or illegal means or by exercise of personal influence. Whoever accepts, here there is no public servant, lords. Whoever accepts or obtains or attempts to obtain from another person for himself or for any other person, in this case, any other person, any undue advantage as a motive or rewards to induce the public servants by corrupt and illegal means. Now, because of this amendment, lords, the corrupt officers, the public servants, and with the person who is assisting him, who is not a public servant, they comes within sweep of this particular provision 7A. And there is a judgment, Mullah. I will just bring that judgment.
Yes, that's settled.
For these people will never come, both are public servant. In this one case, both are public servant. So this section doesn't apply at all. Why he says so, I don't know.
No, it's all right.
Both are
cashier.
Yes, both are public servant.
He is also a public servant.
Yes. Both are public servant. Then, my contention is very short. My lord, he has to, your lordship, see the judgment.
Yes. The impugn judgment, impugn order.
Impugn order.
Yes.
Sorry.
That is 24.
24. Well,
yes.
Page 24. Look what he says. Yes, in first two paragraph, he has stated the vigilance case also. Examine case record. Basing on the written report of the complaint, Suresh Chandra, A case has been registered under section 32, read with 13(1)(d), Prevention of Corruption Act against accused Ramakrishna Prasad and Vasanta Kumar Kamal, who are working in executive engineer PWD number 2
and junior clerk from KCL.
He's acting as junior. Then he has come to settle the position. He has come to settle. Then he has quoted the judgments, different judgments.
Yes, yes.
Page 28 is the conclusion. Page 28.
Page 28, the ground for discharge of the accused itself are not good ground to discharge the accused from
Yes,
the next
that is the only thing he has said. My lord, section says that he has to see the 170. If it has come to your lordship, this order, he must have let something.
But next paragraph he says, the case of the prosecution is nurseries, the complainant. Subhash Chandra so he discussed the facts on merits.
Yes, what he stated, stated what 1,73,000, that is not there, madam. That is now it is 7,000. The trap is for 7,000. 7,000. That they have both of them give a 164 statement. Decoy witness, both of them say, we had been to the engineer. We said that we have brought the money. He said that you give it to case. You give it to case. And they had gone there and give it to the cashier. Cashier counted it and give it within pocket. Then he was captured by the vigilance. This is the case. My lord, what material he has left for your lordship to consider? He has considered the materials in, on the 173 papers, police paper, what is called police papers. He has never stated anything. My lord, one more thing, your lordship see, there is no charge is framed in 120B. There is no connivance. Then how could you go dope me? Our relation between executive engineer and a junior most clerk is such fiduciary relation. They have to obey. But
what is your stand? Why have you accepted the money?
He has told. They say that we are told by the executive engineer to give you the money. And there is no charge of connivance. 120B is not there. Then how could you go to rope me? He has not considered that.
Demand is no demand from your side.
They have given. My lord, this is the first and there is no connivance. 120B, that charge is not there. We have argued that, but that is not reflected. This is the
yes, Mr. Das.
I have
the
no
precise argument is what he says is in the 164 statement of both the docket and complainant, they said that it was given to this petitioner, junior clerk, on the instruction of the engineer. Okay. In the absence of 120B, if this fact is accepted, what are the material you have to rope in this petitioner? Because he has only accepted on the instruction of the senior.
Yes,
unless you say that he has demanded, and he unless you show something that he knew that it's a bribe money.
Yes.
Then how can you rope in the absence of 120B? 120B conspiracy was there. One can understand. There is no conspiracy charge, and nothing is coming out on record to show that he had knowledge that it is a tainted money. And both the docket customer and complainant says that yes, we have given the money to on the instruction of engineer. He being a cashier, he has accepted. Anything to distinguish on facts?
Yes.
Therefore, these things he has argued before the court and which has not been taken.
No. This point was not raised. The 125 concept notes, that was not raised. No.
That fact also is not there.
That is what precise has said. He may be right, he may be wrong.
Well, so
somebody has to decide this issue.
Well,
that's what he says.
Now, one thing is you can say the question of law that can be raised at this stage, but not before the trial courts, because that petition is not there, neither that particular ground was taken. Anyway, my lords, with regard to the
And he has filed the 164 statement of both the
Decoy as well as
decoy.
the whole problem is, my lord, some portions are not readable, my lords. But they worked in tandem, my lords. They worked in tandem, and there was a demand, earlier demands, and also demand on the spot, and he directed him. Se mate tonka lancho davaru, se mate kala tume cashier babunku ja dekha. Setare 10%.
You show me from the impugn order
Manners.
whether the 164 statement, which is now relied upon, has been dealt with by the trial court. That's just see
Extensively. I with great respect extensively. Lords, you can that's why I was placing page 28 minutes.
Yes, 28. Come to 28.
Yes, well, page 28, last paragraph.
Hmm.
The case of the prosecution in nutshell is that the complainant, Subhash Chandrat, who was a A-class contractor, had executed a work, that is, construction of 1cc road from so and so, GP Atgar in the district of Cuttack. After completion, he had received a total lump payment, and when he didn't receive his security deposit of 1,70,000.
This is the fact again. Where is the 164 statement? Where does it say a single word about 164 statement?
No. The cherry para elections. Or Lordship may take it here tomorrow, Lords.
Anything at this stage.
Then after that, to be released, and he made the accused question of
last paragraph, just see page 29, last paragraph. Immediately, a written report of the complainant was presented.
Written report of the complainant was presented before the SP Vigilance. The fact which compelled the complainant to make his grievance before the Vigilance Authority are also carries utmost importance. It is further found that it is premature to say anything at this stage in respect of credibility of statements made by the witness. It can be considered at the trial the role of both the accused persons in the alleged offense as well as their respective pleas as mentioned in the discharge application can well be adjudicated during the trial, keeping in the proposition of law and mind after going through the case records and materials.
Charge is framed.
No, charge is not framed.
Lordship, take it up tomorrow, Lords. I'll come up with.
Why tomorrow? I will do it now.
Why tomorrow?
What I'll do is, insofar as there is a reference of the statement of the witnesses.
Yes,
and court says that that can be the probative value of those evidence will be tested in the trial. But what is his grievance is insofar as these two, the evidence of these witnesses, and 164 statement has not been considered. And while framing charge, let it be considered.
He will raise his points afresh
at the stage of framing of charge once again. The work of this statement of 164 statement has to be looked into.
Lordship, my record is...
Why should you face the trial if nothing is made out? Nothing is made out.
Yes.
Lordship, my record is submission that certain materials on record could not be considered in proper perspective.
At the time of deciding application,
he is granted the leave to raise his
liberty is granted to him to raise
at the time of framing of charge.
Stage of framing of charge. Okay? Yes. You do it so that you get a consolidated.
Your Lordship remanded, he will again hear me in discharge petition.
If your discharge is all right, otherwise you will challenge it.
Okay? Yes.
I will simply say that you are withdrawing it with a liberty to argue.
Otherwise, he will not hear.
No, I'll say that without getting influenced by the observation already made, he will independently decide it.
That observation is the court form, sir.
Okay, and I'll dispose it. That's better, right? In the present petition, petitioner has challenged the order dated 29/4/2024, passed by the Court of Special Judge Vigilance Cuttack in TR case number 28 of 2017, whereby the application moved by the petitioner seeking discharge has been turned down. Learned counsel for the petitioner vehemently argued that the statement of the two witnesses, namely the informant as well as the decoy customer, No, decoy, overhearing witness under 164 CRPC recorded by the prosecution has not been taken into consideration while deciding the application.
And is the entire submission of his crush of his contention is that that as per the statement on section recorded on section 164, they say now
That's what I'm saying.
clearly that directed to give raise 7,000 to the cashier.
That's what I'm saying. Nothing. Decided the application.
After 7,000.
Decided the application. I have gone through the MP note and find no reason to interpret it. However, the grievance of the petitioner could be addressed by the trial court at the and it is all Mr. Das, learned counsel for the grievance, submits that charges have not yet been framed. I'm not interfering you, but liberty is granted to the petitioner to urge this point before the trial court at the time of framing of charges. If such argument is advanced, advanced before at the time of framing of charges, the same shall be dealt with trial court without being influenced by the observation already made in the impugn order dated 29/4/2024. With this observation, the petition is disposed of. Yes. Yes.
My lord, one more thing. My lord, sir, why your lordship said they demand the matter to again hear me on charge?
No, the equivalent to same thing I have done.
No, man. Even if I will come up to your lordship again.
Naturally.
Well, after charge is framed, there is nothing for me to say. Your lordship is satisfied now. This is not a good order.
No, I am not fully satisfied. I tell you, I am not fully satisfied because in the page 29, he says that I have taken into consideration the statement, but he doesn't say I have taken into consideration the statement under 164 or 161. Therefore, that gray area, therefore I am remanding. Otherwise, I am not satisfied. This is a perfect order to be maintained.
Once minor 164, 160 loses its importance.
That is the idea of relegating you to the court. Otherwise, I would not have done it because this is a perfect order. So please take it and that will come to your advantage. Yes, next. 90.
May it please your lordship.
Yes.
This is that cancer
yes.
patient mother's that case memos.
Your lordship, I am to apprise your lordship on the point of sanction.
Yes, yes.
Once there is no charge framed under 120. So that portion also he has not stated in that bill.
That I'll add, and I'll record that also. I don't know. Then the counsel for the petitioner also submits that in the absence of any charge under section 120B, the petitioner cannot be roped into the present case roped into present case simply because of the reason that he has allegedly accepted the bribe on the instruction of the co-accused, who is the senior officer. I am recording his statement.
The submission he will raise.
I have recorded his statement. Yes.
May it please your lordship.
In fact, lordship permit in this case, my learned sister has very effectively argued the matters. The lordship wanted that particular the point on which lordship clinching lords, that the scope of the sanctioning authority, my lords, if they sit over as if they are framing charges for.
No, I didn't follow. I just forgot it. What?
Yes, your lordship. Your lordship, this is that matter where a person had asked for disbursement of medical bills on the account of illness of his mother.
Yes,
your lordship. I am to apprise your lordships on the point of sanction, your lordship. So it is the settled position of law that the investigating
that the peon who is made in the document
interpolation
treatments and 40,000 was sanctioned.
Yes, your lordship.
He was convicted by the
Yes, your lordship. Your Lordship, it's a-
Sanction, yes.
Yes, Your Lordship. Your Lordship, it's a settled position of law that.
I said that if you satisfy one sanction.
Yes, Your Lordship.
Set aside on the ground of sanction, why to go into?
And Lordship also raised an important question of law that whether sanction authorities have said that no, this section should be there, that section should be there.
Yes, yes.
Yeah.
Yes.
Yes.
Now
That you have to address.
Yes, Your Lordship. So, Your Lordship, it has been settled.
Yes, I have asked that whether sanctioning authority, if
Have to
the
put their-
prosecution says that he is liable for this section, can the sanctioning authority choose few of the section and say that no, the other sections are not made out? That means he is exercising judicial power kind of situation. Framing of charge kind of situation. Yes.
Your
Right.
Lordship, though it has been said that there is a need of independent application of mind on the part of the sanctioning authority, Your Lordship. In this case, what has happened is they have given this procedure a total go by, saying that the SP Vigilance has said that since sanction is not required for in this particular case, sanction is not required for PC Act offences, and that is why we are not taking sanction under IPC offences also in this particular case, Your Lordship. However, the position of law is that despite whatever are the suggestion by the sanctioning authority, Your Lordship, the court has to examine whether the sanctioning authority have applied their independent mind while framing the offences, Your Lordship, or while proposing the offences, Your Lordship. This can be done by two ways, Your Lordship. First, the court has to look into that whether while taking the proposal of sanction, all the facts that are involved in this present case or in any case are before the sanctioning authority. And secondly, whether the sanctioning authority has applied its mind to the same. Like the sanctioning authority has to reason out that why this offense is made out and why this offense is not made out, Your Lordship. And so this also can be ascertained in two ways. That first is the original sanction order has to be produced before the learned court. The original sanction order, which again, the original sanction order has to contain the facts of the relevant case, Your Lordship. If there is the original sanction order is not on record, then other documents or other circumstances that point out to such a conclusion have to be presented before this honorable court, Your Lordship. In this present case, Your Lordship, the appellant had this opportunity to challenge the lack of sanction for the first time in his discharge application, Your Lordship. His discharge application has been decided by order dated 24/7/2008. That is at page 10 of the LCR. If I may take Your Lordships to page number 10 of the LCR.
Yes. Page 10, huh?
Yes, Your Lordship.
Yes.
Lordship, page 10 is an order dated 24/7/2008, Your Lordship.
24/7/2008.
Yes, Your Lordship.
Yes.
Yes, Your Lordship. That the court says in the second paragraph of the later order, in this case, charge under 468 and 471 IPC has already been framed against the accused on 27/6/2005. The learned counsel for defense should have raised this point while framing charge. Once charge is framed, there is no provision in CRPC in a case triable by warrant procedure to discharge the accused. Thereafter, two sentences thereafter, the main contention of the learned defense counsel is that authority concerned refused to issue sanction. The word is refuse to issue sanction, which is also evident from the copy of the order passed by Shri Abhay IPS DIG Vigilance Cuttack, wide letter dated 1139, dated 2205 in Bhubaneswar case number so-and-so. Originally, this case was registered under 13(2), read with 13(1)(d) of the PC Act and with section 468 and 471. But charge sheet was submitted under section 468 and 471 IPC only. Sanction is required before taking cognizance in respect of offense under PC Act. So far IPC sections are concerned, sanction is not mandatory. Here he is not given any reason, Your Lordship. And thereafter also, It may be that the prosecuting authority has submitted charge sheet under 468, 471 IPC, leaving the offences of PC Act due to want of sanction. This is contradictory in nature, Your Lordship.
Yes.
It's also, so this leads us to
The prosecution agency has sought for sanction
yes, Your Lordship.
under PC Act.
Yes, Your Lordship. No, both
And it
both
is-
the sections,
both
both
the
the statutes, Your
Since
Lordship.
the sanction was not granted,
Huh.
they choose to file the charge sheet under 468.
They choose to pass this up. And Your Lordship, this order that he is referring to, I will again take Your Lordships to the charge sheet. That is at page number 33 of the LCR.
This was this order decides the application.
Yes, Your Lordship.
Yes. 30. Yes.
3.
Yes.
33 is the final page of the
Charge
charge
sheet,
sheet.
yes.
Yes, Your Lordship. So, Your Lordship, may look at the reasoning in the second paragraph. Though the appointing authority declined to accord sanction of prosecution. So this doesn't make it clear whether is sanction or prosecution for which of the offense under which of the statutes. So this has to be taken in totality, the sanction or prosecution of all the offenses taken together. But during investigation, led evidence to 468, 471 IPC are all collected against the accused person. This is
whether this sanction order,
yes,
declining sanction,
yes,
part
Your-
of record.
Yes, Your Lordship. That is again at page number 40.
Yes. 40. Let us.
Page number 40 is copy of order passed by Shri Abhay IPS on letter dated 1139, that is 2205. That was also referred to in the discharge application, Your Lordship. So far as further course of action is concerned, we may inform the court about refusal of sanction, full stop. However, sanction is not mandatory under 468, 471 IPC. Hence, charge sheet be submitted under 461, 468, 471 of IPC. Since section 420 is not mentioned in SP's report, addition of section 420 IPC at this stage would not look proper, though I understand that an argument can be made out for the same, Your Lordship.
Who is this sanctioning authority? DIG of police. Police guy. He was working in a police department.
Yes, Your Lordship. He is the SP Vigilance, Your Lordship.
What is the reason? Nothing.
The reasoning is, Your Lordship, my contention, I understand that it is a settled position of law that under section 19 of PC Act, it has to be there. The sanction has to be there. Sanction is mandatory. And for all other IPC offenses, it has been contended that if there is a defect in the sanction, if there is any error, then that will not render the case of the prosecution non-est, Your Lordship. But here is a case where they have not accorded sanction at all for prosecution under any of the statute. That is what is my contention.
No, but he says that
It's not mandatory.
not
But
mandatory.
that is again contrary to section 197, Your Lordship. He says that, however, sanction is not mandatory under 468, 471.
You say that this sanction is a complete denial of granting sanction for the public.
Yes, Your Lord. They have given that whole process a go by. They have applied their mind independently, but their mind is application
is necessary for while refusing the sanction. Is it necessary to have a reasoning?
Yes, Your Lordship. That is what the orders from Supreme Court talk about.
This is bereft of any reason.
Yes, Your Lordship.
Rather, he has framed charges. Have you read that?
And I heard it. I heard. In fact, that particular initially it was a turn down. He was absolutely let off by the concerned authorities. Thereafter, my lords, probably they resorted to, they examined different provisions of the IPC.
No, then what basis he says that it is not made out, or I refuse to give sanction. The sanctioning authority has to apply independently. Apply mine.
And,
what are the material placed before him?
And Lordship is correctly saying that there is no ascribed cause and reasons of his opinion.
There is no reasoning. There is nothing. He says that no, not required. But he says that not required. But does he say that you file 420 is also not included? There also he says that no, that can be done. This, what kind of sanction order?
This question of law may be kept open, my lords, for any other cases. But so for this case is concerned, my lord,
I can't keep the question of law open after alive to the fact that there is a question of law.
in this case also.
And which endure to the benefit of the accused. We are in appellate jurisdiction or divisional jurisdiction, whatever. And in 144 Supreme Court can keep the question of law open. But a question of law is there, which endure to the benefit of the accused, has to be answered, and he has to be acquitted.
Has to be dealt with.
It has to be acquitted.
Your Lordship, the Honorable Supreme Court has dealt with this particular question, Your Lordship.
What is it?
However, that the particular question that has been put by Your Lordship, that whether refusal of sanction under PC Act will also render the IPC offences invalid, that has been kept open, Your Lordship.
That question is kept.
That has been kept open. That is why my learned senior is asking, Your Lordship. And Your Lordship, because
Then
that is
the
the
question which is running in my mind is not settled.
Yes, Your Lordship, because the exact wordings are the cases of 2023.
Then
I do
you
have the
do
citation.
one thing, it is kept open, it doesn't say
Your Lordship, but however,
kept open to be decided by Supreme Court only.
no, Your
You can
Lordship,
decide it.
no, Your Lordship. So that is why I mentioned is because I got
You address that issue, I'll decide it here.
Yes, Your Lordship. Your Lordship, in that particular case, Your Lordship, that was a case of defective sanction. Sanction had been awarded.
You have a better case.
I have a better. Why I'm saying that my case is different, because they have totally not cared to propose a sanction, Your Lordship, and they have not applied their mind, Your Lordship. So they have not put any reason that why they are letting go of that whole sanction process. That is what I'm saying. Had they said that this is under 197 also sanction is not required because this is not in usual course of action, usual course of duty, Your Lordship, then I had no case, Your Lordship. Why I'm saying is that the IO also has said that there is no requirement of sanction. So when they are prima facie, admittedly, they are denying that sanction was not required, Your Lordship.
Yes.
But they are not assigning any reason as to such, Your Lordship. Then it's a different case, Your Lordship. And Your Lordship may decide on this point.
In the police manual, there is a police act also, Orissa Police Act.
Yes, Your Lordship. Police manual is there.
Is there any sanction provision like in Delhi Police Act, Section 140?
No, Your Lordship. In Odisha
Section
Police Manual under
140, there is a sanction provision to prosecute any police officer working in the establishment of police in Delhi. There is a provision of Section 140. Do you have a parliamentary provision?
Your Lordship, in Odisha Police Manual, I have not.
Why I am asking there is
yes,
a reason.
yes, Your Lordship, I get
If
it.
he says that no, he doesn't say that the offense complained of is not coming under the official duty or not, in the color of duty or not. It doesn't say. It applies, it indicate from this sanction order that the act which is complained of may be falling under the color of duty. However, since it is a IPC offense, sanction is not required. If there is a parametric provision like 140 in Delhi Police Act, Delhi Police Act, parametric provision, then in that provision at least they should have taken sanction. If not PC Act.
Your Lordship, I'll take you through the evidence of the investigating officer, Your Lordship.
No, that might not have been put to where is
No, that is put to him,
where
Your
is
Lordship.
it? Do you have you checked it whether parametric provision is there or not? I'm putting it tomorrow. Get it.
Your Lordship.
In Orissa Police there is the parametric provision like section 140
Pertaining-
of Delhi Police Act. First read Delhi Police Act 140, section 140.
Yes, Your Lordship.
Then find out parametric provision in Orissa.
Yes, Your Lordship.
Okay.
Your Lordship.
And then you're addressing that. In that case, then we can very well say, if insofar as PC Act is concerned, if the sanction was not required, it's all right. You have to refuse. But having said that, you say that for 468 and 471 IPC offense, sanction is not required. But in fact, it is required under the parametric provisions of 140. Then you can come out.
Yes, Your Lordship.
Okay. Find out. Since you are doing good research, then
Obliged, Your Lordship.
yes.
And in fact, he has covered all the judgment governing the field.
Yes, this is an area where you have to just
But
look at.
only except the gray area which will also be indicated.
Yes, I'm flagging the
Section
gray.
140.
I'm just flagging the gray areas.
I'll also satisfy
It will
that
be a
we are,
watertight case.
I'll also satisfy that we are not inside that gray area. That is why I mentioned the judgment, because I know that my learned senior is always updated with Supreme Court judgments.
Just see, and you get some judgment under section 140 of Delhi Police Act.
Delhi Police Act, yeah.
One of the judgment, I also appeared in that matter, therefore I
Yeah.
have fair idea. It's the reported judgment, just see.
Yeah, Lordship.
Yes.
91. Even Lordship, I pray for next week.
What is this matter?
Matter is, Lordship.
When I opened it, it
Yes,
is written urgent
Urgent?
Orissa High Court. It is written in the top.
I don't know.
Once I open it. So what is the urgent?
In fact, here the petitioners were challenging that confirming judgment, where it is a case under 405, the letter committed under 408 of IPC, Lordship. Allegations are very peculiar. In fact, for last occasion on my pair only this case was adjourned, just because I have to file a written notice submission. For some personal reasons, I couldn't prepare that one. For that reason, I pray next week. But in the meantime, by tomorrow, so I can file it also.
Okay.
So for that reason,
Okay, you are MA speaking.
Lordship, for that.
Yes. Please do it, huh?
92.
After lunch, Mullahs.
No, tomorrow do. 92, na? What is this matter about?
My lords, we had raised 4 points, my lords. My lords, first is, my lords, as per clause 6, they say that some overpayments have been made. So just to briefly recapitulate.
I understand. Clause 6.
Clause 6
contract.
says that these are all interim payments. The ultimate, whatever is the liability or the contractor has to get is by way of the final bill.
Where Mr. Sadangi was appearing. That time.
Mr. Sadangi, I am on behalf of Mr. Sadangi. He is otherwise.
That day he was very hyper, so therefore I adjourned it.
Today
he should be there. Cool,
I'll find out.
cool and composed. He should be there. Sometimes it happens.
Yes, it happens.
As a part of the what do you call it? In the adversary system of justice, this happens.
Otherwise, if your lordship takes it up at 2, I'll ask Mr. Sadangi to come down. I think he is busy.
Yes, because at 3 o'clock I have kept some matter.
Exactly 2 o'clock.
So,
I have totally completed.
How much time will you take, sir?
If a lordship permits, my lord, may I submit, my lords? The case which is to be taken off after lunch, my lords. I know because this vigilance matter special counsel, Mr. Panigiri is arguing, my lords. That case requires more time, my lords. What I suggest, my lord, it can day after tomorrow. I am ready with the notes and everything, my lords.
Which one? That matter?
No, in this case, the day after tomorrow. So that case can be disposed of.
Well, we have already completed our argument.
Yes.
He has already completed.
Yes.
Only you were addressing.
Okay,
that time I think
after lunch,
Sadangi is interjected. He has separate matter.
Then after lunch.
He has to be heard separately. So what do you suggest?
After lunch or day after tomorrow?
2 o'clock, my lords. It will
Because
take hardly half an hour.
my learned friend is aware so many matters, but I am more aware of this court's burden. There are so many matters.
The
then
problem
after
is
lunch.
tomorrow, day after tomorrow, we don't know these bail matters and this
Bail
is
matters.
opening a floodgate, you know.
Yes, sir.
Then you are stuck.
We'll start.
You are stuck. Therefore,
Tomorrow will take that.
2 o'clock, my lords. 2 o'clock, I think.
2 o'clock we'll see.
Take it.
Let it be
My lords,
2:30.
I will just take 3 minutes of your lordship's time, not 1 second more, just to briefly recapitulate and tell your
Let
lordship.
it be 2:30 because
My
there are a couple of passover matters.
Yes, well, 2:30.
2:30. Let us see what.
Yes,
Okay.
2:30. We have also filed a list of dates and.
Yes, that I have. That is there.
Oblige.
93.
May I please, your lordship?
Not may I pray, my lords, this matters, my lord, 90.
If your lordship may fix it to 1st August or 2nd August or tomorrow, day after tomorrow, I will take only 10 minutes, my lord.
But
I filed the
see, today 10 minutes it's all right, but tomorrow 10 minutes we don't know.
Because he is not there because of
Because he has personal problem. Put it after 1 week, we'll see.
Look, next week, because your lordship may kindly see my client is there is 77 years old.
I understand.
And this is a 93 case below.
I know.
Original case. 30 years has elapsed. His wife has also died in May. And he's suffering a lot, my lord.
I see. What can I do? I'm
Exactly.
trying
That's
to.
why taking his predicament only, your lordship, but please to fix it up with particular date.
See which day it will give.
The 1st August, my lord, 1st August, even at 2 o'clock, I will only written notes of.
Why? By the way, this is an appeal. Why are you calling your client?
No, no.
The old man, why are you traveling?
No, he has come for his treatment. So, in AMS.
But don't next time don't call. If you want
I have not
if
called.
you want to watch, he can watch through the live streaming. Why should you call him? Don't call. Just see which day you can give. Fix it. He'll fix it up. And
Great.
94 ଟା ଟିକେ ଆଉ ଦିନେ ଆସୁ
I am there in 94.
I have already requested that କହିଥିଲି ତ ଆଉ ଦିନେ ଆସୁ ସେଟା
ଆଉ ଦିନ ଆସୁ Mr. Pada, I started laughing.
In fact, they already.
This is he's smiling only.
The smile
indicates that
speaks volumes.
Because he must be thinking that every time you do that.
Mr. Ponda's smiles, in fact, speaks volumes.
So when do you want now? Yes.
Let them say.
21 ରେ ଆସୁ 21 ର 12 ଦେବେ
I'll say that no further agenda.
It's a
the request of Mr. Marana, meets the matter on service day. It's made clear that no further adjournment shall be given. Please do it. These matters are pending. See, 2017 matters.
Last 2 days he has
Yes, therefore, yeah, okay, it's all right. Personal problems are always there. No.
We'll do it.
Next. More finish. Pass over anything? You pass over?
Mr. Pandey,
okay.
and the vehicle was sold to the person.
Yes, yes, yes.
And the finance was made.
Yes, yes, Mr. Raut. What is the status?
My lord, the warranty has yet not been arrested, but I have taken several steps. Like I have conducted raids and also kept civil surveillance in front of his house since then. And
What kind of surveillance? Do you have the mobile number of that accused?
No, not my lord. No, my lord. I have got the mobile numbers of his parents. I have kept them in tracking whether he is talking with your parents or not. Proclamation. I have also obtained proclamation against him, my lord, from the honorable court.
How much time will you take?
My lord, if 4 weeks time may be given, I think I can arrest him.
And I have also talked with him that he has taken some major steps to arrest the accused person, and his parents they are also not cooperating. They are staying.
So their phone number is their phone number from their phone number you can track.
No, he has
the
bring
accused
the
may contact sometime.
he has bring
He may contact with his parents. That's why I'm tracking their phone numbers.
So at least after 3 weeks. At least after 3 weeks. We'll see. At least after 3 weeks. Simply urge another request. Huh? Please. Thank you very much. Please try. Please try. Okay. Thank you very much. Please try. Yes.
61. 61. Let's say I'm applying for the opposite party number 2. Should I enter my appearance number?
This is regarding what?
Yes, let's not bail. CRL.
Offenses under section 3762N, 341, 294, and 506. Law and Code below has granted him bail. He has challenged the same, that why bail was granted by
what is the ground?
No, but why the bail was granted by the court below, that is the ground. And in the condition, when the law and code below has put some conditions, that condition number 2 is that, my lord, that he shall not threaten or influence the informant or victim and other prosecution witness.
Has he threatened?
No, my lord. Subsequently, one FIR was lodged. In the FIR, the informant stated that some unknown persons, they have threatened me that you withdraw the case, which was filed against the accused persons. And he suspected that the informant suspect that on the behest of that accused person, these 2 persons, they have threatened. So in the FIR was registered against unknown person, including the accused persons. But he was not present on the spot. When the threatening was given, it was accused was not present on the spot.
So then he can move application for before the trial court. I'll give that liberty.
Yes, because my lord, his sole ground is that why the law and code below has granted bail.
What is the offense? What is the offense?
3762N.
Merit ready, yeah. Right on. Non-APS for the petitioner, even in the second call. I peruse the impugn order dated 27/4/2024, passed by second additional sessions as Cuttack in BLAPL number 488 of 2024, whereby the court below had enlarged the opposite party number 2 on bail. On bail. So appears and files Procedural. Pushpamitra Mahapatra and associates have filed the Bogalakrama on behalf of opposite party number 2, which is taken up the court. Third opposite party number 2, non-appears for petitioner even in the second call. it is alleged that after the petitioner was enlarged in bail, he has violated the condition of bail. There is an FIR lodged subsequent to the impugn order on 8/4/2024.
Madam, subsequent FIR is on 4/5/2024. Page 22, madam.
Huh? Page
22.
22. Impugn order, subsequent to the impugn order, an FIR was registered on 4/5/2024. It is entirely alleged that the petitioner is involved in the same case. In that view of the matter, the petitioner, opposite party number 2 is involved in the same case. In that view of the matter, petitioner submits that the opposite party has violated the bail condition. Next, I mean, not inclined to interfere in this matter. However, liberty is granted to the petitioner to move to the trial court in the event of any violation of the bail condition. Appropriate orders will be passed by the court below in that regard. In this observation, the petitioner is clear.
62.
Yeah. What is this matter?
This is a private party. State was not a party. It's a bank, National Fertilizer Limited. In this case, the noting is that a defect is also there. Defect is also there, my Lord's may directed that he is not appearing. Lord's may directed to remove the defect.
Challenging the cognizance order. Cognizance order. Yeah, what are the objections? The present petition is filed by the petitioner on 1/11/2023. Certain objections are pointed out by the registry, which has not yet been cured. By way of last and final opportunity, 2 days time granted to the petitioner to cure the defect. In the event the defect is not cured by by 2nd of August, the present petition shall be dismissed without reference to the court. In the event the defects are cured, release the matter in the next week. Yes.
66.
What is this? Defects. The same article. The petition is filed on 2/11/2023. Defects are pointed out. Otherwise, yes.
67.
There were non-appeals. Yes.
67.
67 also defects. Defects are there.
Same. Same problem. Same problem. Non-appeals, same thing. It was filed on 2/11/2023. Okay.
69.
Yes. You have the same problem? Defect code?
Small defect. Small defect. Small defect.
Yes, what is this matter? Cognizance again. Just check it up.
Refer 3-6. Maharaj, out of a 1-6 case, one. I have challenged 2 orders. Order 15/2/2023. Enact, 114 Act, paying the condonation delay filing of complaint.
Advising soon. Connection, he has filed the corona pandemic, so and so, the delay was not intentional, but so and so, immediately due to corona pandemic, the court was not functioning fully with so and so, but the delay has sufficient ground to condone the delay, but the delay is intention to protection to the one of my interpreter of the checkpoints. We do that. Of the safe will not be escape from technical ground. This will be satisfied with reasons from 25 days, and hence in the interest of justice, the petition is the delay in the presenting the 25 days delay.
And
The
also
lawyer was suffering, and the pandemic restrictions were there. Therefore, 25 days delay condone. He is challenging that.
Another order is there, 4-5 ballot, 4-5 ballot, BW issued. BW issued. Another, they had challenged 2 dates, my lord. 2 of the order. 4-5 ballot. 4-5.
Another is
last order.
4-5. In this present petition, petitioner is challenging the order dated 15/2/2023, whereby the delay of 25 days has been condoned, and the complaint under section 130 Act against the opposite party, against the petitioner, has been entertained. And the second order and the order dated 4/5/2023, whereby the bailable warrant has been issued against the petitioner. I have perused the order dated 15/2/2023, passed by the JMFC 4 Kotak in the complaint case. I am fully satisfied satisfied on the reasons. Satisfied. I am in fully agreement with the Learned Trial Court for condoning the on the ground the delay has been condoned. The lawyer who was conducting the case for the complainant was suffering from respiratory tract infection, and he has filed the photocopy of the medical document. Apart from that, due to pandemic restrictions, the complaint case could not be filed within the period provided under law. Therefore, it suffered a delay of 25 days. The trial court, by a region order, has condoned the delay. I find no reason to interfere in this matter. However, insofar as the order dated 5/4/2023 is concerned, I am inclined to interfere in this matter, and the bailable warrant issued to the petitioner is set aside, subject to condition that the petitioner shall appear before the court on or before 30th of August and seek remedy available to him under law. With this observation, the petition is disposed. Yes. None appears for the petition. Yes.
And also defect are that we mentioned, defect. two
Defects
defects
pointed out with the registry.
Not removed.
Ignored.
73.
May I please, my lord?
I am for the opposite party.
Yeah.
May I please, my lord?
Yes.
This is a matter wherein the order of the learned court below is under challenge. That is why criminal revision number 5 of 2023.
Yes.
Wherein the Honorable Court was pleased to confirm the order passed in MC case number 99 of 2022,
Yes.
wherein the learned SHM directed to recover the area maintenance. The only ground that I have shot before the learned revisional court and before this Honorable Court,
You are the husband.
I am the husband, my lord.
Yes.
Initially, a warrant was issued for rupees 1,80,000.
Hmm.
I entered appearance and I filed an application stating that only 48,000 as per 0.25(3) is required to be paid and rest amount cannot be levied due to the bar under 125(3). On that ground, I filed an application. Though 48 warrant was recalled, but the learned court below directed to pay the rest amount within a
What was the maintenance amount awarded?
About my lord, 128 application was filed by the present opposite party number 1 and 2 being petitioner before the court below for realization of amount of rupees 1,80,000. The maintenance amount per month was passed to the tune of 4,000, 2,000 each. So challenging that order passed in MC.
You are now continuously paying or not?
My lord, I am paying, my lord.
He says no.
Yes, my lord, I have proof. Even in the learned court below had granted me stay on that ground.
We had filed the application in the year 2014. Till date, they have only paid 14,000. And last order was that the further proceeding in the miscase has remained.
What is happening to the marriage?
They are regarding separately.
That's right. Regarding obviously separately. Have you initiated any proceeding for?
Yes, my lord. Section 10 application have been signed before the Honorable District Judge Assistant Judge, my lord. Jaipur.
What is the stage?
For dissolution of marriage, my lord, and Special Marriage Act.
What is the stage?
Stage, my lord, notice have been issued and opposite party have appeared in that case. For it is posted for filing of the counter by the opposite party.
There is no application there for maintenance.
For maintenance, my lord, for maintenance, this is the sole application that has been filed for recovery. And no further application for maintenance is.
So you have paid 48,000 out of 180.
180 I have paid 48,000. And as per your lordship's order, I have paid last 3 months for your lordship had categorically directed me to keep on paying. And in the event of payment, the MC 99 of 2022 shall be stayed. So for last 3 months, I have paid, my lord. Receipts have also been filed and she had received before the Honorable Court below.
See, the respondents are your wife and your daughter.
My lord.
Isn't it? You have to pay. What are you doing, by the way, for living?
My lord, I have paid, my lord.
What are you doing for living?
I'm an employee in Nalco, my lord.
Then what is the problem in paying 4,000 rupees?
I'm paying, my lord.
Paying in a 40. Why have you not paid one out of 1,80,000? Only 48 you have paid and fighting the case on technical grounds.
But my lord, that is the only why I'm praying, my lord. What had happened is 125(3). Your lordship very well knows that there is a rider under 125(3) that.
No, I don't know anything. I don't know anything. I only know one thing. That 1,80,000 rupees you have to pay to your wife and your daughter since you are earning. That much I know.
I bow down to that effect, my lord. My humble.
Pay the money. You forget about the technicality. They are wife and your daughter only.
Your honor would appreciate one thing, my lord. Just one thing, if your honor would permit me.
Technically, you may have a good case. I am not on technicality. You have to pay it.
Another problem lies. What had happened is, on this ground, I am before your lordship. What she had done, she had filed another petition for recovery under money suit. That is also lying. Notice have not been issued to me. So if I will be paying this, the money suit doesn't go, my lord. It still survives.
Obviously, you have filed a recovery suit also.
Yes, my lord. Money suit number 15.
See, I will send both of you to go to the district mediation center, sort it out and come next week.
My lord.
See, if he is paying the money, why are you filing suit and all unnecessary?
I will take instruction because.
Okay. No instruction, no instruction. I am disposing it, I am sending to mediation. Right out. In this petition, petitioner has challenged. Petitioner is the wife of, petitioner is the husband of opposite party number 1 and father of opposite party number 2. In this, this petition is arising out of the maintenance proceeding initiated by the wife, that is opposite party number 1. There was a direction for payment of maintenance at the rate of 2,000 for the opposite party number 1 and 2,000 for opposite party number 2. Since the arrear is accumulated, the opposite party insisted for recovery of the same. This present proceeding is arising out of the said recovery proceeding. The petitioner is challenging the proceeding, challenging the order dated 4/11/2023, passed by the additional district and session judge Karaput in criminal revision petition 5 of 2023 on various grounds. Since the matter is arising out of a matrimonial discord, I am not inclined to entertain this petition at this stage. However, I relegate the parties to appear before the district mediation center for sorting out their differences and differences. The parties are directed to appear before the district mediation center on a particular date, on 2nd August, so and so, or any day to be fixed by the coordinator of the mediation cell, and explore the possibility of a settlement. With this observation, the petition is disposed of.
My lord, till then I may pay, my lord. I may be protected because my salary attachment have been directed.
If that threat is there, then only you will settle. Otherwise, you will never settle.
No, my lord, I am paying as per your lordship direction. I am paying monthly.
I can't dispose it up. I release the matter after 1 week along with the mediation report.
My lord. Till then, interim order to be continued, my lord.
Nothing will happen, don't worry. Yes.
77.
Yeah.
Please, your lordship. As per direction, I am filing the DD, which is memo.
Take you take it and close it.
Yeah.
The present revision petition is arising out of the judgment dated 26/5/2009, passed by the learned additional session judge Thenkanal in criminal appeal number 37 for 2008, whereby the judgment of conviction and order of sentence dated 31/7/2008, passed by the learned STJM Thenkanal in ICC case number 550 of 2000. The petitioner has been confirmed by the petitioner has been convicted and sentenced by the trial court, which is confirmed by the appellate court. Therefore, the present revision petition has been filed by the petitioner. At this stage, when the matter was heard, the petitioner agreed to make good the entire check amount to the opposite party and furnished a draft of rupees 45,000 draft hearing number so and so of rupees 45,000. Opposite party has accepted the amount to his full satisfaction, and full satisfaction. In view of the aforementioned development, the impugn order dated so and so is quashed, and petitioner is acquitted from the offence. Conclude under section 138. The bail is permanent, stands discharged. Yes. फोटोकॉपी रख दो ओरिजिनल, ठीक है? डिस्पोजल. Yes. 28.
I discovered the release of the documents. Update.
Yes.
Let's we discuss the matters. In fact, 13 plots have been seized. Documents brought in 13 plots. Where
13 plots.
13 plots under 13 cell deeds were seized by the vigilance. On their cases, not that because of the ill-gotten money. But my learned friends say that the cell deed at serial number 64, 65, 67, 68, 69, only 5 cell deeds may be released. He got the instruction from his clients. Go on.
I'll furnish the bank guarantee, my lord. Bank guarantee.
Let's release that one.
No, I didn't follow.
She wants the release of this 5 cell deeds, my lords. 64, and that if lords turn to annexure 2, my lords.
Annexure 2.
Page 28.
Place 20.
Yes.
Place 28, my lord, that serial number, the cell deed stands at serial number. RDS, registered cell deeds, my lords. 64 to 69. 64, 65, then 67, 68, 69.
64 to?
No, 64 to 65.
C6. Release of those documents.
No, I repeat, my lords. 64, 65, 67, 68, 69. I'm giving that paper, my lords. I was jotted down.
So what do you want now?
That she wants that these 5 cell deeds be released on furnishing securities.
Which 64 to 69?
69.
With the corresponding ROs. With the corresponding ROs.
But how will you value it? Evaluation is there.
Value is there.
That will be that exercise will taken off by the.
Value is there.
No, I think the value is there.
There.
See, every
RST, the amount is written. Value.
amount is written. 166, 1,66,000 and all this. So calculate. Have you calculated what is the total amount?
Around 26 lakh.
Around, no, you have to, bank guarantee means I can't write around. You have to tell exactly figure.
Exact
You have to
add
it. See, the figure is already given. And if the documents are released with 2 conditions, one condition is she will furnish a bank guarantee of equivalent amount, whatever. And she will not create third party interest in so far as or
undertaking
deal with this document.
She will furnish undertakings.
By the, what will you do with these documents?
Yes. No reason as well. In fact, she has fairly stated he has not resorted to any falsehood.
See, for furnishing bank guarantee, try to be practical. For furnishing bank guarantee, you have to arrange the money and that equivalent amount you have to arrange. And you, even if you get it, you can't deal with it.
In fact, my instruction is that she is now serving, getting the salaries. So there is no financial crunch, nor any physical ailments of the.
No, but what will you do? What she will do with this original document?
That is obvious, my lord. That will be present to service for obvious reasons, my lords.
Have you taken instruction?
Well,
but this part, have you told that there will be a no, I will pass an order that you will not create third party interest or you will not deal with the document in any manner whatsoever. You must be, your client must be thinking that he will give me bank guarantee here and sell the property there. That must be the idea. Must be thinking that in that line. You please seek proper instruction. Don't make that confusion.
I have taken instruction that bank guarantee is ready to furnish the bank.
To that extent, I understand. Bank guarantee, I pass that on and release the document.
In fact, that raises eyebrows. In fact, my grandmother also sharing that thing. But sale deeds, my lords, ultimately what she will do, my lords?
That's what I'm
Yes,
asking.
collateral amount is to deposit there. Otherwise, bank guarantee will not create it at all.
That restriction would be there. I'll pass that restriction order. Then what will you do with this paper?
At least here.
Now
it is
today you
secure
see
garage.
26 lakhs unnecessary. 26 lakhs will be at stake.
That 26 lakhs he can use it.
He
for
use
his
it,
business.
brother.
And my
What
friend,
benefit you are going on? I will pass this order if you say that's not a problem. But I'm thinking of
my friend, my lords, is a MSc in mathematics.
I even know that.
That's why he is very good in calculation mathematics.
just seek instruction, madam. It may be prejudicial to your client. Seek instruction, proper instruction. Ask two things. One is the total amount, whatever amount is coming, about 26 lakhs. You have to give a bank guarantee, and thereafter I will release all the documents to you, but with a condition that you will not create third-party interest, or you will not deal with this document, because these are the she's document which has to be tested in the trial. You can't alter it. And as and when the court required, you have to produce it, the original.
Time nature, time.
During trial, if the originals are required, it will be summoned from you. So therefore, you have to keep it with you. So better they let it be there with the police.
That's why
Safely it is
that
there.
this is more safe.
More so you just seek instruction. They might not have understood the consequences.
And the things are now safe in the custody. And that too now the money will be invested here.
Unless it is 26 lakhs, it will be at the stake.
It's better let her take
Better you take
instruction.
How one? Clear instruction, otherwise you will be in trouble. Yes. Next. 81. Yes.
Lords, I beg to appear for the petitioner, my lords. Am I audible?
Yes.
Yes. My lords, this is a quashing petition, my lords. I am seeking quashing of the charge sheet, the supplementary charge sheet, and the cognizance order. I'll explain the allegations in brief, my lords. There was a contract that was awarded to me by Madhya Pradesh Road Development Corporation Limited. The total project cost was about 124 crores.
No, you show me the charge sheet, whether there are enough allegation or not. Let us see. If allegations are there, you have to, the law will take its own course. I can't
I'll show
get into
my lords, in fact, I just wanted to point out right at the threshold, there has been a one-time settlement with the bank. And my lords, I'm relying on two decisions of the Supreme Court, my lords, in Nikhil Merchant versus CBI and BB Agarwal versus CBI, where there was a one-time settlement with the complainant bank, and CBI was the prosecuting agency, where Supreme Court quashed those cases, my lords, criminal prosecution. I'll make good that argument, my lords. I'll point those cases out. In fact, if my lords want to see the charge sheet first, if I could just give a brief background.
What is the second case you said?
BB Agarwal, sir. BB Agarwal versus CBI.
Who is appearing for the bank?
Miss Pratyusha Nayak, my lords.
I'm appearing, Your Lordships.
BB Agarwal is the 2019 volume 15 SEC, that judgment?
My lord.
Yes, Mr. Naidu, are you agreeing to that fact that you are the complainant, you have settled the matter with the accused?
That is on record, Your Lordships. I have settled. The bank has agreed to a notice before the DRT, and that, in fact, that is annexed as well. So I cannot bypass.
But are you do you have any objection if it is closed? The prosecution is closed.
Lordships, here what has happened, there are some errand officials of our bank also, and they have also been added in. So my entire thing is the entire loan process, be that the initiation or the ending, has been done up in such a hurried and in such a manner. That is the reason the officials of the bank are also...
Show me your OTS. Show me your OTS condition.
My lords, may kindly see page 157 of the paper book.
In the OTS condition, if it is specific there, then...
no, in OTS condition, it is written that your lordship's criminal action will continue.
Then can't help it.
No, my lords, if I may just point out.
There is a letter dated, your lordship, there is a letter dated 28/3/2019.
Where is OTS? Show me.
My lords, it's at page 157, the letter that Mr. Nayak is pointing out, letter dated 28/3/2019. If I may just read out.
Point number 5.
My lords, if I may read from the starting. My lords, this is annexure 13 of the paper book.
13, okay. Yes.
My lords have the page 157. On the subject matter, please take the reference of your above letter. We are pleased to inform you that our higher authorities have accepted your OTS offer of rupees 40 crores and approved the proposal on the condition mentioned hereunder. Upfront amount of rupees 4 crore deposited by you, which is presently kept under no lien, will be accessed for immediately towards your dues.
Immediately towards your dues.
For your dues, you have to pay rupees 6 crores by 31st March 2019. Remaining amount of rupees 30 crores to be paid in 3 quarterly equal installments of rupees 10 crore each by 30th June 2019, 30th September 2019, and 31st.
I am not interested in notice. You must be emphasizing on para 6.
Well, para 5
All
is
the
what
litigation filed by you against the bank
shall be withdrawn. But in fairness, I must point out para 5, which Mr. Nayak and which Ms. Naidu want to point out. I'll read
will continue.
Will continue. Now, my lords, here I wanted to submit. My lords, this is a simple OTS letter, my lords. Here, no official of the bank is going to say that the criminal matters will come to an end. He doesn't have any authority. Only my lords can quash it. If suppose he were to say that criminal matters will come to an end, would Mr. Nayak agree? Mr. Nayak
Then
would not agree.
Then forget about that ground. I have settled the dispute, therefore,
Yes.
Come to the merit.
Yes, my lords. So what I am trying to impress upon my lords is, I've made a compilation of judgments, my lords. What I'll do is, if my lords can permit me to come down on next Tuesday, physically, I'll share it with Mr. Nayak and Ms. Naidu.
For this matter, what compilation is required?
I've read all the
judgments.
judgments.
Show me 2, 3 things. I'll
My
dispose
lords,
it up right here.
my lords, I'll just show those judgments then. In that case, my lords, may kindly have my colleague Mr. Pulakesh is there. If he
What
can,
is the proposition?
my lords, I'll point out. The proposition is, if there is a one-time settlement with the bank, then there is no necessary for a prosecution to continue, my lords. No purpose will be solved. What is the crux of the allegation of the bank? They went to CBI by saying that we had disbursed 62 crore rupees. And now what has happened is Madhya Pradesh Road Development
Then in
Corporation.
all the theft case, once the stolen articles are recovered, the cases has to be dropped.
My lords, in fact, I'll point out in Narinder versus CBI, my lords, these guidelines have been made by Supreme Court, in which cases where after especially if this is a commercial transaction and money has exchanged hands and the money has gone back, in those cases where the guidelines have been given, where cases can be closed. I'll point out that also. That's also part of the compilation. So if my colleague can pass on the compilation, my lords, Mr. Pulakesh has the compilation. There are some judgments here.
Then I'll put it
Tuesday, my lords.
When do you want?
My lords, could it be Tuesday? Could it be Tuesday?
Tuesday, let it be Tuesday. Yes, Mr. Naik.
Your Lordship, after 15th August, Your Lordship may put it.
Small matter, let us finish, Mr. Naik.
Your Lordship, next week actually I'm traveling and I'm also not well, Your Lordships, because I need some treatment.
Put it.
After 15th any date, Your Lordship, 17th, 18th.
Are you enjoying a stay?
No, my lords, I'm not.
Put it.
Should I give any specific?
The charges are 468, 471.
No, my lord. No forgery, my lords. No forgery. 420 and 13(1)(d) and 13(2) because some bank official is there.
In the meantime, Your Lordship, she was arrested by ED. I would like to also place
My
those
lords, I wanted to point that out, that before the lunch break, this was pointed out. Nobody from this company has been arrested. I will request Mr. Naik to place the documents of arrest. I point out, my lords, I'm saying this on instructions with some responsibility. Nobody from this company has been arrested by ED or Mr. Naik's client CBI. He can place the documents. There's enough of prejudice being created, but it's okay.
But anyway, you have a difficult case to face. Let us see.
My lords, I'll try to impress upon my lords. I'll try.
Very
I'll make an endeavor, my lords.
Lordships, the meanwhile, the compilation may be shared with us.
I'll share.
Please share the compilation with the Lordships.
I'll share, my lord.
Mr. Naik as well as Ms. Naik. Okay.
I'll do that, my lord. My lords, what date
The
my
bank
lords?
officers have filed any proceeding?
No, Your Lordships.
They are not asking for quashing.
No, they are not. They're still
Your
in
Lordship,
service.
in fact, Your Lordship, the bank officials and this person, they both are co-accused. They have cheated. And how can both the co-accused compromise among themselves? He's an accused, he's an accused. Both have cheated.
No.
This money belongs to the taxpayers. Bank is only a custodian of the taxpayer. They both have cheated the public, Your Lordships.
I must clarify.
How can both the co-accused compromise among themselves and solve the
The
proceedings?
bank is the complainant and bank officers are the accused.
Yes.
And my lords, I
Bank
must
and the
clarify.
accused both are co-accused. They have cheated the public because the money belongs to the public and bank is only a custodian.
My lords,
Bank is not accused. Bank is in fact the the officers and these private persons have cheated the bank.
And my lord's
somehow
bank.
somehow they got back the money, doesn't mean that the crime will be washed away.
My lords, I'll point out.
That is your case. That is your case.
After
But
getting back the
he says Supreme Court has said that once the settlement is done, the cases are to be quashed. Let us see that.
Yes, let him show.
If on facts it can be distinguishable, we'll see. Otherwise, this
Absolutely, my lords. My lords, what date are my lords?
22nd.
22nd. Very well, my lords.
Yes, next.
I'm so grateful, my lords. So grateful.
92. Yes, 92.
92 minutes. Now we're going only 5 minutes late because of that senior advocates matters minutes. So
let us see. I'll stretch another 10 minutes.
Number 10. I'm going to respond to 5 revision matters. At least 5 minutes.
He has already argued, and
more or less everyone is at
everybody is
not everyone. I have not touched. I have to answer each person's complicity, and 5 cases are there. 4 was there, another has added 5 cases. At least 5 minutes may not be too unreasonable.
Not 5 minutes. I'll give you another 10 minutes.
No, I am ready with the pen. Ready to come tomorrow minutes, because the senior advocates they are provided with the time of 3 minutes. That's it.
No, Mr. Kanungo has already argued. Mr. Sodangi has also argued.
But at least I need a half an hour minimum. Sergio.
Tomorrow. Tomorrow?
Yes, no problem.
Tomorrow 3 o'clock.
Oh, yes.
Tomorrow 3 o'clock. Because I have already heard, and unnecessary hearing time will be wasted.
No, I am ready with notes and all this thing, but I need at least to place each individual matters. 5 cases I have to respond. Otherwise, I will failing my duties.
Are you going to add anything from your side?
Prepared a note. I have given the document.
You will not be arguing then.
Whatever he says, if I require.
For rejoinder, you can get it. For rejoinder, you will get it.
Otherwise, 5 grounds what my learned senior has said.
These are the same ground you have covered.
That contract, then 2 years after inspection, then CC2 PT, whether that power exists or not.
He has covered all the points.
I am appearing for the JE. Against the allegation has been raised, I have to explain.
So I will take a little bit contract.
Tempering of measurement.
Overwriting and all you have done. Keep it there. Keep it there and give it to. So from your side, it is over then. For the top of the rejoinder, you will what? 3 o'clock.
Okay.
In that connected method, I am for the contractor, the last day, part operation.
Forget about delay. Come to the merit. What delay? Black wala. Ramesh Chandra. Delay kanun.
To refresh the argument that I advanced earlier, my lord, the allegation is that the I will. But before that, I just within 2 minutes I was representing what argument I had advanced. The allegation against the present petitioner is that was the power of attorney holder of the lessee and he had performed illegal mining in area outside the leasehold area of the lessee, that is the leasehold area of one Jagdish Chandra Mishra and the area under the forest. That is the allegation. Your Lordship wanted to know as to whether Your Lordship wanted to know as to whether Jagdish Mishra had, it was pointed out that Jagdish Mishra had also executed a power of attorney in favor of the petitioner, although his lease was cancelled by the government. And your Lordship wanted to know then why he had executed the power of attorney. Yes. And wanted me to file a copy of the power of attorney, originally seized by the investigating agency during investigation. I have filed the copy in which it indicates that Jagdish Mishra had executed the power of attorney as he had challenged the cancellation of the lease before this honorable court, and in order to process that application and to do all the needful regarding the mining if he succeeds in that application. So there was no delivery of possession of the land by Jagdish Mishra to the present petitioner by way of the said power of attorney. Now, coming to the ingredients of the offense, I had submitted, Lordship, that the ingredients of the offense under 13(1)(c) and D is not made out, as the petitioner is not a public servant within the meaning of the Prevention of Corruption Act. So far as the offense under section 409 of the Penal Code is concerned, I had submitted, Lordship, that the basic ingredients of the offense is that
No entrustment.
no entrustment, and secondly, I submitted about the charge, Lordship, that the charge must be limited to 1 year, section 212 of the CRPC, and if the period of offense is from 2004 to 2009, and accordingly I placed the relevant decision to that score and submitted, Lordship, that the charge needs to be quashed. Now, Lordship, there is another point regarding 409 which I had omitted. Lordship, in the case of Gopal Chandra Sinha and others versus State of Jharkhand, 2021 Criminal Law Journal 381, Lordship, in this case, which is there in my compilation of the citations at page 62, 63, Lordship. Lordship may kindly see, it begins from 62, 63.
Separate for how will you handle it like this? And my note is also not.
The compilation of the judgments which I had given. Lordship got it?
Yes.
Lordship. Para 3, Lordship. Page 62. Para 3, line number 4 of para 3. I can come directly. In the said FIR, while working as senior executive engineer civil, Bhuli Town Administration, BCCL, Dhanbad, during the period of October 93 to January 94, entered into a criminal conspiracy with the appellant convict Gopal Prasad Sinha, the proprietor of Mrs. Gopal Engineering, Pujari Prasad, a private person, and the co-convict Bhagwan Das, who died during the pendency of the trial, and others. In furtherance of said criminal conspiracy, dishonestly and fraudulently misappropriation of 302.840 MT of non-coking coal, grade C, worth of 1.5 lakh, which was meant for distribution amongst the employees of BCCL for domestic use was caused by the accused persons of the case, causing a wrongful loss to the tune of 1.5 lakh to BCCL, a government of India undertaking, and wrongful gain to themselves. This is the allegation. Now, Lordship may kindly come to page 75. Page 75, para number 39.
Yes.
Coming to the facts of this case, the allegation against the appellants are that the appellant Gopal Prasad Sinha, in capacity of the proprietor of Messrs. Gopal Engineering, was entrusted with the job of transportation of coal from the collieries to the Woolley township, and during the transportation of coal, instead of dumping the coal in the said township, Gopal Prasad Sinha misappropriated the said coal. The allegation against the appellant Pujari Prasad is that he, being the power of attorney holder of Gopal Prasad Sinha, is also responsible for the said misappropriation. In view of the discussions made above, this court is of the considered view that neither Gopal Prasad Sinha nor Pujari Prasad comes under either public servant or banker, merchant, factor, broker, attorney, or agent as mentioned in section 409 of Indian Penal Code, as though Pujari Prasad may be the attorney of Gopal Prasad Sinha, but the said Gopal Prasad Sinha, having himself not coming under the above categories, certainly Pujari Prasad cannot come
Being
under
a
those.
power of attorney, you will also not.
It means, Lordship, that the word attorney appearing in 409 IPC means that he is the attorney of the person who had entrusted. And it cannot be meant that he is the attorney of the agent. So my case is similar.
Gopal, Jagdish Mishra has interested you.
No, BK Mohanty.
BK Mohanty has interested.
BK Mohanty had entrusted his leasehold area. His leasehold area. And the misappropriation.
He can prosecute you, if at all, he can prosecute you under 409.
Yes,
but not the state.
But not the state.
Yes.
Now, coming to the, then I stated about 420 of the Indian Penal Code, that it is, the cheating is done for the purpose of inducing delivery of property. And here, the ingredients are not met. I have never cheated the state or the government to induce for delivery of the property. And accordingly, the ingredients of 420 are not met out.
Right.
Now I come to section 468. So far as 468 is concerned, your Lordship may kindly see 468, forgery for purpose of cheating. Whoever commits forgery intending that the document or electronic record forged shall be used for the purpose of cheating shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. So, forgery for the purpose of cheating, forgery and cheating. Forgery is done for the purpose of cheating. Now, forgery is defined in section 463 of the Indian Penal Code.
Right.
Lordship may kindly see.
Right.
Whoever makes any false document or false electronic record, this part is not the case, false document to the public or to any person or to support any claim or title or to cause any person to part with property or to enter into any express or implied contract or with intent to commit fraud or that fraud may be committed, commits forgery. So the first line makes it very clear that making of a false document amounts to forgery. The purposes are there. The initial part is that making of a false document amounts to forgery. What is false document is defined in 464. Lordship may kindly see. A person is said to make a false document first who dishonestly or fraudulently makes, signs, seals, or executes a document or part of a document. B, makes or transmits any electronic record or part of any electronic record. C, affixes any electronic signature on any electronic record. D, mine is the old IPC, makes any mark denoting the
But you have
execution.
not created any document for that.
No, no false document. So what I beg to submit.
In the entire transaction, only one document is involved, that is the power of attorney.
Power of attorney. The document becomes a false document only when the seal signature appearing in the document is false.
Yes.
If there is some false recital in the document, then the document does not make a false document within the meaning of this section. To give an example, let us say a board certificate. The board certificate becomes a false document only when the signature of the issuing person is false. Let us say that the date of birth mentioned therein or the division mentioned therein is false. That does not make the document a false document within the meaning of this section.
Right.
So there is absolutely no allegation in the entire case of the prosecution that I have made any false document.
Then PC Act 13(1).
13(1).
All these things you are not public servant.
Yes, yes.
409 you explain.
Not made out.
420 also you explain.
Not
468 also you have explained.
Not made out. Next offense is 379. So far as the offense under 379 is concerned, Lordship, it is very common that the property is being taken away without the consent of the owner. Then only 379 takes place. And herein, the property has been excavated with the permission of the state. Royalty has been paid. And it is within the knowledge of the state. So how can 379 be attracted? And so far as 379 is concerned, in the written argument submitted by my learned friend, he has pointed out that I had raised the account maintained by the raising contractor, the person who took out the ore, the raising contractor, the transporter, yes, and transports it to the crosser for the purpose of getting the ore. Therein, 65 lakh and odd ton has been mentioned. I had mentioned to the government that I had raised 47 lakh and odd ton for which royalty has been paid. It is the case of the prosecution that the amount, the differential amount is the theft committed by me, which is absolutely against basic human common sense. The raising portion is called run of the mines, ROM, that is called. That contains earth materials, that contains other waste materials. And when it is taken to the crusher and separated, then only the ore come out. And your Lordship knows that when ore comes out, fines are also produced. Yes. And fines are not in the same category as the ores. So the run of the mine has been taken as the quantity, and it is alleged, it is there in the written note submitted by my learned friend appearing for the vigilance also. So the allegation of theft cannot be made out. And so far as the receiving of the stolen property under Section 411 of the Penal Code is concerned, since theft is alleged against me, both cannot go together. And moreover, it is stated that the stolen property was received by the Deepak Steel and Power Limited, for which I am not arguing. Deepak Steel and Power Limited is another company, and I am not for that. And Deepak Steel and Power Company Limited is represented by another accused. That is the father of the present petitioner, who is the managing director of the said company.
You are supposed to give a write-up. I told you.
And
I
Lordship,
told you that day, you have to give a write-up against every this thing, what are the judgment you have cited in paragraph.
yes, I have given. The note of
that-
submissions I have given, and this list of citations I have given, the compilations of the judgments I have given, and the compilation of the documents I have relied on also I have given. Lordship, the last offense is the offense under section 120B of the Penal Code. And so far as 120B is of the Indian Penal Code is concerned, there is no ingredient of 120A. There is no meeting of minds. And
preceding the crime.
In fact, my submission is that I have not committed any crime. However, if it is stated that there is illegal mining, and my mines were inspected, Lordship, I did the mining from 2004 to 2009. And as I submitted earlier, your Lordship remembers that I had submitted an application, the lessee had submitted an application for renewal of the mine in 2003, and there was an inspection, there was a report regarding that, which I have filed in the document I have filed today. Lordship, may kindly come to that.
Yes.
The last page, Lordship, may kindly come of that, which is the checklist for disposal of the RML application. And the last page, Lordship.
These documents are part of
the prosecution document. These are all part of prosecution documents. It is mentioned in the charge sheet. Checklist for disposal of RML application. Lordship, got it?
Yes.
Now, Lordship, may kindly come to the last page. Serial number 6.
Yes.
Whether boundary pillars are intact in the field or not. Intact. It was in 2010. My mining was up to 2009. And the inspection made by the vigilance is in 2013.
You can put this thing to the witness.
Yes, but the document speaks, Lordship, on the face of it. And whatever mining I had done is within that area, which was shown to me by B.K. Mohanty at the time of giving the power of attorney. And the boundary pillars were intact by that. The boundary pillars of the mining area. And they say that at the time when the joint physical verification was conducted, the boundary pillars were not there.
This is Mohanty's area.
Yes.
But what about Mishra's area?
Mishra's area, whatever mining I had done, Lordship, is within Mohanty's area.
But the prosecution says...
Prosecution says that it was partly in Jagdish Mishra's area and partly in reserve forest area. And Lordship will find from this report, which is there, that the area of Jagdish Mishra...
Prosecution is saying that you haven't done anything in B.K.
Mohanty's area.
This intact theory supports their case. You have not done anything.
No, Lordship.
This shows that entire mining within B.K. Mohanty.
B.K. Mohanty's area,
No,
whatever mining I have
whether the
done.
boundary pillars are intact.
Intact.
Or not. It is intact.
Yes. But they say, Lordship, that at the time when the joint physical verification was done, the boundary pillars were not there, which is after this. I completed the mining in 2009.
Where from you will get that checklist when this was carried out?
2010, Lordship, it is there.
1/10/2010.
Yes.
Yes.
And this officer is not an accused.
And now coming to the next point, Lordship.
They are not able to handle this, this 5, 6, 8 accused. Now having 18
He is
accused.
not an accused. Then I
Now 18 accused, they are not able to handle. Why should they?
And what happens, Lordship? What happens? It is very common. It is in the statute itself that wherever mining is permitted, the mine is annually inspected by the Indian Bureau of Mines in order to ascertain as to whether mining is done in accordance with the mining plan or there is any violation. And each year there is a report from 2004 when I commenced the mining to 2009. Each year there is annual report which is reflected in their case, and nowhere it is pointed
To
out.
answer me in so far as B.K. Mohanty and Jagdish Mishra is concerned.
By Commission, and the extent of illegal mining as regards B.K. Mohanty was. How can?
But there is an illegal mining.
There is the
extent of illegal mining is something different.
Yeah, it may be.
Extent you can question, saying that once
And another
15 crores, 15,000.
And another important, I have in fact submitted the mining, the list showing the extent of illegal mining and the compensation in the list of documents that I have submitted. That last document.
What have the Jagdish?
Jagdish Mishra was not there. He was not a mine holder by then.
Yet no area had been given to him.
Judgment.
His lease was suspended or cancelled.
I know.
And he filed a writ application in the honorable court. That writ application, he challenged that cancellation of the lease.
List of documents, Lordship,
the power of attorney is for that I look after that.
Lordship, the list of documents which I have submitted, document number 5 in the list. The true Xerox copy of order number MXIIID 77/16 7818/DM dated 38/17 of the page. It runs from 297 to 318 of the compilations of documents.
Yes.
297 it starts, Lordship.
Yes.
This is the demand notices were issued, and then the letter of the Directorate of Mines, and then the list of the persons, wherein the name B.K. Mohanty is also there. Uliburu Iron Ore Mines is at serial number.
Okay, I understand. Let us hear Mr. Pani.
Lordship, one more point, Lordship. What I have submitted is that in this case, common cause, there was a submission that cases be permitted to be instituted in CBI. And the Honorable Apex Court refused that and fixed compensation. My humble submission herein is that, Lordship, there are 178 cases in Odisha, and in many of the cases, the amount of illegal mining is more than my amount that has been pointed out. And yet, the state has not prosecuted any of them. So why I am singled out, Lordship? And that is why I submit that my prosecution is completely malified. And moreover, Lordship, I beg to submit that the ingredients of the offense not having been made out in the allegations made by the prosecution, the charge is completely unfounded, Lordship, and needs to be quashed.
Yes, thank you. इसको separate करना है. Very difficult to handle. Separate करना.
Yes. May
Any submission? Take it out and change. Thank you for everything. Yes. इसको साथ written submission के साथ. Yes, sir.
Yes, my lord. First of all, my lord, I would like to bring
the last question first. Why have you singled out this mine owner to prosecute, not prosecuting other people after common cause?
No, my lord. He has not given the true facts, my lord. My lord, here what is the allegation? Allegation in the FIR. Allegation in the. My lord, am I not audible?
No, there is some disturbance. 1 minute. Just take it out.
Lord, is it okay now? No. Wait.
Just take it out. Take out the written note. Yes.
I have given a written note.
Yes.
I will place also. My lord, here my learned friend has argued the whole matter in merit. Now your lordship knows the settled position of law as the apex court has laid down in Sajan Singh's case and others, that from the FIR and charge sheet allegations, whether there is a prima facie case to proceed against the accused. At this stage, my lord, while framing charge, the court is not going to see whether he has committed the offense, whether there is a likelihood that he might have committed the offense. So this is the whole thing. If there is any doubt, the apex court says, then charge must be framed and he must be tried. Now question is, my lord, here, my lord, your lordship will kindly say this is one of the biggest economic offenses of the state. And in India at the similar time, there were illegal mining in most of the states, for which 1,000 crores of rupees of revenue have been lost to the government. Here our loss is, my lord, 1,500 to 1,600 crores. So far as Orissa is concerned, this is a high amount. Lordship will kindly see this Deepak Gupta, who is the mastermind and Ringo. Am I audible now?
Yes,
yes. This Deepak Gupta, who is the principal accused in this case. That has been, I am not saying that, because the matter has come to this Honorable Court more than 20 times by different accused persons. At least Deepak Gupta has come 10 times. Then other accused have come. So in every case...
10 times for quashing?
No, for quashing the criminal proceeding, he filed criminal miscase, he filed writ petition along with his family members. Because all the family members, they have formed company, illegal company. One company was selling to the other company. That is the allegation, my lord. Sneha Pushpa Marketing Private Limited. That there, my lord, the directors are, my lord, this Deepak Gupta, his parents, then wife, brother, and here also in this Deepak Steel, the same persons are directors. Now question is, my lord, one company was selling to the other, and the allegation is, my lord, that this B.K. Mahanti, who had earlier taken in the nutshell, I am saying, you lordship have now masterminded this. Deepak, this B.K. Mahanti, who had earlier a permit to operate lease, his period had lapsed. He filed renewal application not in time. It should have been filed 1 year before, but he filed few days before its expiry.
So his case was not considered. But yet, he executed a power of attorney in favor of this Deepak Gupta to execute mine. Then after that, Jagdish Mishra, whose area is adjacent to this BK Manthi's area, he also executed a power of attorney and gave wide powers to this Deepak Gupta to do all business in respect of his mine. So what happened? What Deepak Gupta did, he made a conspiracy with the forest officers. He made a conspiracy with the revenue officers and the forest revenue and other officers to make a conspiracy so that together they can, illegally operate these mines, sell the products and distribute the amounts. Now, I don't say that 1600 has been only pocketed by this fellow. He must have taken the lion's share, but others officers are there. Now, question is, my lord, he charged therefore under 120B. My friend's main argument in this case is that he is a private person. How can he be charged under section 13(1) of the Prevention of Corruption Act? How can he be charged under section 409? It's not that, but the law is clear, not by this honorable court relying on apex court decision as held. I will take it to your lordships that once there is a conspiracy, section 10 of the Evidence Act also your lordship will keep in mind. 120A, section 10 of the Evidence Act. Once there is a criminal conspiracy and all persons together, my lord, they meet to do an illegal thing and that illegal thing is committed, then each of them is liable to be prosecuted under every offense. So now if your lordships for the prima facie accept criminal conspiracy, because without the aid of conspiracy with these forest officers, with these revenue officers, this could not be possible, my lord. This could not be possible at all. And if conspiracy is prima facie there, then Deepak Gupta is bound to be prosecuted under section 13(1), 409 as the government officers are being prosecuted. So there are 28 accused persons. Out of them, 2 are companies, that is Neopushpa Marketing Society Private Limited, and Miller, the other one is Deepak Steel. Then 26 accused persons are different government servants, then 5 family members of this Deepak Gupta himself and others. So now question is, my lord, the entire argument that he is a private person, he cannot be prosecuted, but that goes. And the direct decision, first of all, you also will see 99 Supreme Court. 99 Supreme Court. Milord, I think it is page is. But this decision, in fact, I could not give in my note, but let's will. This is page. Page Millard 2556 page.
25?
And see, I will take your lordship to only one observation.
Have you filed those judgments?
Very short.
Have you filed those judgments?
This judgment I have not filed because I will be filing by tomorrow. Because this judgment I got, its binding is such, it could not be photocopied. But here it says
2000. What is the citation?
Well, citation is 2000, a 99 Supreme Court, page 2556. 2556.
Volume?
This is volume 2, my lord, volume 2.
Yes.
Lord, I will give this copy tomorrow, my lord. I may be permitted to only read one paragraph of this judgment, my lord.
Hmm.
My lord, that is paragraph 22. Paragraph 22 and paragraph 23. My lord, paragraph 22 says, Sri Shanti Bhushan, but I am just reading a very short paragraph.
Yes.
Sri Shanti Bhushan cited certain illustrations which, according to us, would amplify the cases of abatement fitting with each of the three clauses of section 107 of the Penal Code, vis-a-vis section 13(1)(c) of the Prevention of Corruption Act. This was there. The first illustration cited is this: a close relative of the public servant tells him of how other public servants have become more wealthy by receiving bribes, and A persuades the public servant to do the same in order to become rich, and the public servant acts as accordingly. If it is a proved position, there cannot be any doubt that A had abated the offense by illustration. But there are three illustrations I am not reading. I am only reading the operative portions. Such illustrations are apt examples of how the offense under section 13(1)(e) of the Prevention of Corruption Act can be abated by not public servants. Kindly see, by not public servants. The only mode of prosecution of such offender is through the trial envisaged in PC Act. And the other decisions, my lord, kindly see, I have given in my written note. Now you will may look at my note, that is at page towards the last. My lord, page 23, Lord Simesi. Page 23 of my written note.
Yes. 2017.
Yes. 17 Supreme Court 2161. In paras 455, it was specifically held the most important aspect of offense of conspiracy is that apart from being a distinct statutory offense, all the parties to the conspiracy are liable for the act of each other, and as such, and as an exception to the general law in the case of conspiracy intent, that is mens rea alone constitute a crime as per section 10 of the Evidence Act. Let's keep 10 section 10 in mind. Once reasonable ground is shown for believing that two or more persons have conspired to commit an offense,
No,
then
what are
anything
what I understand, this is the proposition of law. What
Yes.
what are the material you have for 120B?
Mirror 120, mirror this, kindly see, this now that is prima facie, there is allegations of illegal mining from Jagdish Mishra's lapsed mining lease and Ulibur forest. This is the allegation. And Millard, Jagdish Mishra himself has lost complaint before the authorities that from my area illegal mining is going on. This is what the FIR and the charge sheet they show. So therefore, and other materials are to be they are to come out while during trial. So this itself is sufficient that there is a prima facie allegation, Millard. Your Lordship is not going to decide whether he has committed this, he may be acquitted.
Absolutely.
Yes. Yes. So therefore, will kindly see. Then another case, my lord, I have taken into that is Asian Resurfacing Road Agency's case, AIR 18 Supreme Court 2039. My lord, here what I want to point out, here two things were decided. One is it was filed against framing of charge. In that decision, the Honorable Court said that if the court is granting a stay order, then it must maximally valid for 6 months, which was subsequently set aside by the larger bench in that Allahabad Bar Association case. The Lordship knows that recently. We are not on that point. But the basic point which I am pointing out, here the Apex Court has held that yes, a criminal revision may be filed challenging framing of charge, but court will only interfere in rarest of rare cases. So your lordship has, and that finding is not yet disturbed by any bench. Even the subsequent larger bench, the only question was referred whether that 6 months period is valid or invalid. Yes. So therefore, the Honorable Court says the jurisdiction of the High Court exercising either a revisional or inherent power should here revisional should be exercised against order framing of charge in rarest of rare cases. But is it a rarest of rare cases? If the FIR and the charge sheet, which runs to 100 pages, each page consists of allegation against Deepak Gupta, and all judges previously, while deciding criminal bail applications and other applications, they are amply described the facts. All are speaking orders. And they have said that there are enough materials to proceed against this person. So candidate said that this is the rarest of rare cases. It's not, absolutely not. He must be tried. He has committed a blatant economic offense.
Who is this Bimal Prasanna Acharya?
Bimal Prasanna Acharya, he is a forest assistant conservator of forest. He filed, yes, I am coming to that. He filed also a case before this Honorable Court challenging the framing of charge against him. That has been rejected by a speaking order. Lordship, that I have given, there are two decisions, one by Bimal Prasad Acharya, another Mahant. Milord, that is page 39 to 53. Kindly see page 39 to 53 of my note.
Yes.
Milord, here, Milord, this is 39 is Rabindra Mahanta. He is, Milord, one of the accused, I think accused number 15. Accused number 15, and he is the ex-forester. Forest officer, Milord. Milord, here the Lords will kindly see, Milord, the past, say, page 40, the second para, order dated 5/6/17, passed by the special judge, Vigilance Keunjhar, in so and so, framing charge against the petitioner under section 13(2), reduced section so and so, is challenged in this application. So by this very order 5/6, the charge against the present petitioner Deepak Gupta has been framed. So here their lordship says, no, there is nothing, there are material to proceed against the accused, and at this stage the charge cannot be quashed. And the findings are, kindly see, paragraph 6, page 42. However, it is seen that charges were framed not only against the petitioner, but against other co-accused persons by the very same impugned order. Therefore, this court is not inclined to quash the order of framing charge. Then, my lord, Lordship may see Bimal Acharya. Next page, page 44. He was the assistant conservator of forest, Keonjhar, at the time of this crime, my lord. My lord, here also, the Lordship, my lord, paragraph 2, page 45, his Lordship has given the factual backdrop of the case from the FIR and charge sheet. Then, paragraph.
What is the finding of the court? These are the facts.
Yes, finding is I am taking to the last finding is the Lordship. Para 5, kindly see para 5, page 48. It was found out that, kindly see, it was found out that illegal mining activities of the lessees.
Para 5, para 5.
Para 5, page 48.
Yes.
Yes. It was found out that the illegal mining activities of the lessees and the power of attorney holder Sri Deepak Gupta continued for a long time, spreading over a period of about 6 years from 2004 to 2009. It is alleged that the illegal operation continued with the knowledge of the mining officials as well as the forest and revenue officials, causing a huge loss of about 1,523 and odd crores paise to the state exchequer. It is further alleged that the present petitioner was working as assistant conservator of forest, Keonjhar, during the period of 2006 to 2009, and hence the illegal mining activities was within his knowledge or should have come to his knowledge if he would have made a field verification during these years. It has been alleged that regular verification of the forest land and boundary are the statutory jobs of the petitioner as a forest official, but it was not done facilitating the illegal activities of the lessees. So there are earlier findings that illegal mining was going on, and their lordships have not interfered. This is, Millard, kindly see paragraph 8, the further discussion about this conspiracy. Paragraph 8, page 51 in the middle. Learned Senior Counsel also submitted that. Learned Senior Counsel also, lordship, got it?
I got it.
Yes. Learned
There
Senior
has been
Counsel
no
also.
illegality in framing of the charges.
That illegality in framing of charge for all the offences against the petitioner, since there is an offence under section 120B of the Indian Penal Code implicating the petitioner for being a member of the criminal conspiracy in committing the alleged offences. The Learned Senior Counsel for the State Vigilance also placed before the court the details of the allegations found out in course of investigation against the present petitioner as well as other government officials.
I read the full judgment.
Yes. So therefore, my lord, and paragraph 9, his lordship goes to show how a private person can be considered. Page 9, my lord. His lordship has quoted section 120A, etc.
I have seen page 9, 120A is described.
Yes, yes, quoted.
They say that since 120B is there, therefore there is no question of interpretation.
Therefore, they are finding. Yes. Then your lordship may see from this note, I am pointing out another finding of an honorable court previously on this point, my lord. Just, I think it will be page. My lord, can only see.
These are the prosecution evidence already recorded, 53 people.
No, 53 already recorded. And
how many total?
Total is 100.
178. 178.
I think we have to cut short it but finally it was about 147. 147. So, and there are a large number of documents, 55,000 pages of documents to be proved.
How much time are you going to take?
Me, Miller?
No.
Trial. Well, I'm coming to that. Lordship, see, this is a very big case. And what happened? This petitioner 6 times moved bail application in this Hon'Ble Court. All applications are rejected with speaking orders, not that hard bail rejected, long speaking orders. Then twice rejected by the apex court against this bail order. What happened? Third time when the petitioner went to the apex court, at that time, I think this was during just before Corona time, Supreme Court was taking a view, those who are already suffered incarceration for 7 years or more, they should be released. So by then, he completed 7 years inside jail. That is how he got a release order from the apex court. And twice this
He has already undergone 7 years.
Yes, Miller.
7 years. 7 years in jail. He only, others were all in bail. Others are all in bail.
Are you sure after conviction also he will get this much sentence?
My lord?
After conviction, the trial court is going to give this much
That
sentence?
is 409 is there. That is life imprisonment.
Has seen what is charge.
No, 409 is, well, what I am suggesting, let my learned friend give this amount with interest to the state. And so that state can be, at least do that money
No,
with
the
some.
question is after common cause, you said 380 crores and you have taken it.
No, that is BK Mahanti. My learned friend is showing that is a report in respect of BK Mahanti.
And I am same.
And that is not.
What about Jagdish?
Jagdish is not
Yes.
there.
Jagdish is not there in common cause.
Jagdish is not there.
Allegation is in the Jagdish area we have done it.
Jagdish area.
Miller,
Gullipur is not there, my lord.
Vigilance says.
That is what the test is.
But
common
cause, the committee, they visited the site, they have inspected, they did not find any mining in Jagdish Mishra land.
Show me that. Show me that.
Jagdish Mishra is not there, Miller.
Not there doesn't mean anything. You show me that in Jagdish area, it was inspected and it was said that there is no mining. Then it is a case of
Jagdish Mishra, no area is there. He has not been given any area.
You have to.
Lordship, 1 minute, Lordship. I am making it clear, Lordship. All illegal mining sites were inspected by the expert committee during Shah Commission. It was measured. And all these expert committee, when it referred to the illegal mining committed by BK Mohanty.
I understand, sir. I understand everything. But show me anything, a scrap of paper that in Jagdish area, inspection was done and it was decided after common cause that there is no.
Lordship, kindly appreciate.
Even if those documents I will not consider here. It is you have a 482 petition. It will be cost entire thing.
Lordship, the question herein is that I am regarding the charge. And my point is that whether the ingredients, whether there are allegations.
Those things I am not on that.
Yes, Lordship.
That is the test.
Yeah.
Whether this particular charge is made out or that particular charge is made out from the material on record.
From the material on record.
That you have
Lordship.
argued, no problem.
Lordship.
I am just thinking 7 years he has already undergone.
Yes.
Then what kind of sentence you are going to award him after, even if you convict him?
No, Miller, 409 is there.
Minus 409.
Yes.
Minus 409 goes, then?
No. If 409 goes, I think all of other offences are within 7 years. That is not the point. Point is he has to be, there is no question 409 will go, Miller. We shall have to establish this. There is enough material, Miller. And such a case should not be tried. If my learned friend is so sure, why is not trying his luck there to to be acquitted there.
He tried his luck for 7 years to come out.
For,
No,
for
no, he
another
was-
20 years, I am to
That's,
face trial.
that's the reason he's
That is
worried.
what he is saying.
Milord, he was arrested in 2013. And since then, he has been knocking the doors of this Honorable Court and
So
Apex Court.
therefore, the delay in the prosecution cannot be attributable to a person who is in custody. 7 years he was in custody. If it is delayed, it is only prosecution is responsible, not the accused.
Your Lordship, that may be Milord, who is responsible or not, that's a different thing. And this Honorable Court has held that the accused himself is responsible. Because at the initial time,
How he was in custody, how can you see that?
That was because of some misleading.
Milord, kindly see.
And there is no stay of proceeding at his.
No, not at all.
There is no
Not
stay of
at
proceeding.
no point of time.
Milord, the
There was
matter,
stay.
Milord, the matter twice was heard by this Honorable Court by one Honorable Judge, and he passed a speaking order running to Milord 50 pages, where he has found that several times this accused has taken time. Whenever the case is posted for trial, he has filed application for adjournment.
No, absolutely misleading. Never I have filed application.
Not misleading.
Never.
1 minute,
No,
sir.
don't use
Do you have that?
word. You were
Sir,
not there in those cases.
Do you have that order, the judgment, whatever you are?
That judgment I can file tomorrow, Milord.
Please try that. And
Yes.
point out where is that.
Yes, I can file tomorrow. Milord, better, your Lordship will, suppose I give that judgment, but I can't argue that this paragraph or that paragraph.
I'll give some time to you also.
That's what I'm saying.
Because see, worry is a person remain 7 years in the jail.
Now he is outside, Milord.
And 2013 today, 11 years trial, 7 years in custody. For how many years?
No, that's but that is no ground, Milord. That is no ground to Milord. What's the charge, Milord?
I am not asking that.
Milord, many cases, Milord, many accused persons, they have suffered this way. And this is a big case, Milord. And you said 149
Big
witnesses.
case has to be given big importance by the prosecution. You should have
that is
given much
right.
importance to conclude it.
You will also may see that 409, I will just, for today's purpose, I will end with that. And I will kindly see page 18 of
I'll put it day after tomorrow. You come with and please come physically so that it will be easier, if possible.
Well, physically, I am very sorry. But I was a regular goer, but my mobility is impacted now.
Okay, it's all right. No problem. You don't come, but please tell your assistant, whoever is assisting you, should be there in the courts with the papers, whatever papers.
Okay,
Your assisting
that,
counsel.
that I can do. I will
Please do
send
that.
my.
And you join in VC, no problem. But the assisting counsel should be there at least.
Yes.
In the court.
Yes,
So that if any papers are required, then immediately, he can give it.
I will give the papers with me.
And I'll put it day after tomorrow.
Day after tomorrow.
At 3 o'clock. Again. I'll take just 10 minutes to you. I have heard them.
Yes.
Only I wanted to finish this point, this 409, which your Lordship is saying.
Yes.
Just that's a finding. That's a finding of the Honorable Court in the previous proceeding. Kindly see. In respect of this accused.
Bail order. Finding in the bail order.
Whatever.
Finding of the Honorable Court in
Which
bail
order?
order.
Have you filed that?
Yes.
Where is that?
Finding
No.
in the bail order, is that?
Page 18. Page 18. Page 18 of my note. Page 18 of my note.
Yes.
Mirror here, the paragraph is 3. The further factual contention. Let's make kindly see.
Further contention.
Yes. The further tactical contention that the ingredients of offense under section 409 of the Indian.
Yes.
Yes.
For that, yes.
Yes. the further tactical contention that the ingredients of offense under section 409 of the Indian Penal Code are not attracted against the petitioner, as he is neither a public servant nor he was entrusted with the property by the state, is also not acceptable, inasmuch as there are serious allegations against the public servants who were to safeguard the valuable properties of the state and being dominion over the properties in the capacity of public servants have failed to discharge their statutory duty and entered into criminal conspiracy with the petitioner and others and facilitated dishonest use.
No, it says there is entrustment to the public servant. He is a private person. If at all there is any entrustment, it is only the Mohanty or Jagdish might have Mishra might have entrusted, but the government is not interested. Here the finding is entrustment is to the government servant.
Correct. So if the government servant is roped with criminal conspiracy with this person,
okay,
then
you
whatever
120B, therefore he is also involved.
he is also 120B and section 10. That is the whole thing, Millard.
What you are trying to say is even 409 is made out is not made out simpliciter, but for 120B he is also in 401.
That is what I am saying. That is my contention. And here Lordship, he has repelled all these accused persons who are non-public servants. Kindly see bottom paragraph. Accused persons who are non-public servants can also be prosecuted for abatement of the offense or being a party to criminal conspiracy along with the public servants concerned under section 409 of the Indian Penal Code, as the crime was allegedly committed in connivance with both the parties or after entering into criminal conspiracy. Reference 99 Supreme Court 2556, which I read out first. And I said that even a private person can be tried under section 13(1) of the Prevention of Corruption Act. So his contention has been taken care in this way. The crime was then, kindly say, the crime was committed continuously for years together in a cool, calculated and organized manner, causing loss of thousands of crores to the government exchequer. There are prima facie material showing involvement of the petitioner. Petitioner is Deepak Gupta. Petitioner in the deep-rooted conspiracy with other co-accused persons, including the public servants. What more clear findings should have been there?
This is the order passed in his bail application.
Yes. And the criminal number I have given here, I will give the whole judgment if will. This is page 17. This is order dated 28/3 top 28/3/2016 in BLA PL number 854 of 2015. And Millard, each bail order is a long speaking order, 6 times by this Honorable Court. And these arguments were made each time before the Honorable Court earlier and repelled.
Yes.
And my learned friend his argument is that he is just a private person, therefore I can be charged under certain. I understand.
At this stage also you argued. You invited a finding.
No,
yes.
That is not at that stage charge had not been framed. Here I am just
against the charge.
Charge was not framed. Charge was framed long back. What my learned friend is saying?
No.
I have given. Kindly see. Kindly see
this is an order in the year 2016, 28/3/2016. When the charge?
2017.
Millard, kindly see. The first page charge was framed on 31st December 2013. And this is the order passed in 2016.
5/3/2017 charges were framed.
What?
5, 6,
No, no, I am not framing of charge. Charge sheet was
the day
filed.
of June 2017.
Charge sheet was filed.
Yes.
Because when the charge sheet is filed, there the evidence doesn't come.
So
Only
what he's saying is these observations were made at the bail stage where charge was not framed. Thereafter, when the charge was at the stage of framing of charges, they have argued it which was not attended to. That's
no,
what
no.
their case.
Miller, framing of the charge will not change the situation. Here,
Okay, day after, you please send someone with the judgment copy and all. Day after.
at 3 o'clock.
May I point out just one thing, one sentence? My learned friend submitted that if there is an
I am
allegation
not
under
completed.
section 120B of the penal code, then the person conspiring must be tried
what
for
he said
all
that-
other offences.
Yes, individually you might not.
Let him point out a single decision to that effect.
No. As if all the judgments are saying that.
No.
If individually, if you have committed something
120B
under the aid of 120B, you can be roped in for the other.
No, 120B lordship is a substantive offense by itself.
But the judge, you have to decide those judgments.
And the person will not be tried for the other offenses.
But the judgments are
those judgments are not on that score. Not a single judgment is there.
Let us.
I
With
will
the aid of 120B, the other offenses can also be roped in.
With the aid of 120B, he can be charged, but not for the substantive offense. There is a distinction. Here I have been charged on 13(2), 409, 420 substantive offenses, not with the aid of 120B. What he says, had I been charged with the aid of 120B, that takes care. But here I have been charged with substantive offenses of 13(2).
Along with 120B.
No, not along with 120B. Your Lordship sees the charge. Not along with 120.
A separate 120.
Separate. 120B is separate.
That's the distinction.
That is the distinction.
You had answered that, sir. That thin distinction he is showing that. We'll see that.
Miller, what he is saying, there may be a technical error, but what are the facts? Consecutive
that can be
facts.
looked into in the trial also, yes.
Yes. Miller, day after tomorrow, 3 o'clock.
Sir, Pranam Sangram, sir.
SKV Narayan.
Yes.